Good morning. Welcome to this year's Environmental Law and Policy Annual Review Conference, now webinar, or LPAR, as we call it. I'm Linda Bragan. I'm a senior attorney with the Environmental Law Institute and also a lecturer in law at Vanderbilt Law School. So it's been quite an unusual year for all of us and for LPAR as well. We would certainly prefer to be in Washington together as we usually are, but we are delighted that so many of you could be with us today. We appreciate especially you loyal fans who return each year, and I want to just send a special welcome to the Vanderbilt Law student alumni who are listening in. We are very pleased this year to have two co-sponsors for this event, the DC Bar Environment, Energy and Natural Resources Committee and the Women's Council on Energy and the Environment. So it has been well over a decade, which is hard for me to believe, that ELI and Vanderbilt have collaborated on this effort in which Vanderbilt law students work to identify some of the most important ideas from the legal academic literature each year, and then try to bring them to policymakers and practitioners as we are today. We definitely could not do this without the help of our stellar advisory committee of public and private sector leaders who advise the students, and their names are on both the ELI and the Vanderbilt LPAR websites. Many of them have been doing this for years, and we are greatly appreciative. And as you may know, the articles that we select each year and that you're going to hear about today are published in form with the commentaries you're going to hear in the Environmental Law Reporter every August in a special issue. So I do want to thank the ELR team for making this all work, particularly Jay Austin and Rachel Jean-Baptiste and Bill Strub. You're going to learn more about the process we use to select the articles in just a minute from our wonderful third-year Vanderbilt Law students. But now I want to turn it over to Mike Vandenberg to talk about what we're trying to achieve with LPAR. Mike is a chaired professor at Vanderbilt Law School and director of the Climate Change Research Network. He's also my co-instructor for the course at Vanderbilt and also a close family member. So you will actually see him sharing the screen with me later today. Mike, over to you.
Great, thanks so much, Linda, and welcome to everyone on behalf of Vanderbilt University and Vanderbilt University Law School. We've got four principal goals here, and the first is to migrate the best ideas we can identify from the academy into the policy process. And I think that's more important than ever this year and in recent years, because the policy process has gotten so thin and so partisan. And our hope is to have broad, thoughtful panels reviewing some of the best ideas in the environmental law literature. Another important idea and goal of our project is to try to create incentives for people who are scholars to produce actual viable policy recommendations in their scholarship. When I first started writing articles, the first thing everyone said, all my colleagues in the academy, was take out all the policy ideas. That won't get you anywhere. And that's just upside down, and we're trying to address that. The third and related idea is that we think the theoretical and empirical scholarship in the academy will be much better if scholars have to wrestle with the real policy constraints that exist out there. They'll be doing better work, and so their theoretical work will be better if they have to engage with the things that so many people in our audience here today and our panelists know are limits on what you can do. And then lastly, and maybe most important, what you'll see throughout the day today is that our students are playing a leading role on these panels, and they play a leading role in the article selection and the editing, et cetera. And we're trying to provide a first-rate experience, something that's absolutely novel in the United States for these students, and an educational experience is something that we hope they won't ever forget. And as Linda mentioned, we're particularly excited with the growing group of alumni we have, many of whom are on the line today. So with that, I'd like to turn the program now over to Brian Davidson, who's been just an excellent editor-in-chief over the course of the last year, and he's going to take us the next step down the way.
Thank you, Professor. Hello, everybody. My name is Brian Davidson, and I am this year's editor-in-chief for LPAR. On behalf of LPAR, we are so excited to see you all here and to see this conference come to fruition. We started this process over a year ago with 200 the journal, 24 articles. And after reviewing each article and discussing in class as a journal, we narrowed the pool down to 20 articles for our advisory committee to review. With the committee's input, we selected 6 articles to publish in this year's annual review. I applaud the authors for their work because it is not an easy feat to publish an LPAR. To qualify for selection, the article must meet two prongs. First, the article must address an environmental quality issue of major importance. And second, offer a law or policy-related proposal or approach to rectify the problem. After qualification, we consider additional factors for publication. We debate whether the article is persuasive, impactful, creative, and feasible. It is this rigorous process that has led us to select only the 4 articles which we will be hearing about today, as well as 2 articles for honorable mention. After selection, LPAR students condense the chosen articles, emphasizing the proposal for policymakers and practitioners to evaluate. ELI then helps recruit experts to comment on the articles to broaden the discussion. LPAR members edit these comments for publication alongside the condensed articles. Finally, the process concludes with a symposium held virtually today, but typically in Washington, D.C., where we host panel discussions with the authors and expert policymakers and practitioners. So to start this year's conference, I'd like to turn it over to Stefan Berthelsen, snapshot of this year's article selection data.
Good morning, and thanks, Brian. As Brian said, my name is Stefan Berthelsen, and I'm a third-year Vanderbilt Law student and have served as the LPAR Development Editor this year. As part of my role, I keep track of the data and trends in environmental law scholarship. This morning, I'd like to give you a brief snapshot of the environmental publication data we have recorded this year. As Brian described, we have an established methodology for evaluating articles and collecting data. If you are interested in a more detailed look at this process, the full information on our methodology can be found at this link on the ELI website. This year, we analyzed 224 environmental law articles. Of these 224 articles, 99 came from general law reviews, and 125 came from environmental law journals. We classify the articles into 10 topic categories, which are set out by the Environmental Law Reporter's Subject Matter Index. These topics include air, climate change, energy, governance, land use, natural resources, toxic substances, waste, water, and wildlife. Articles receive a primary topic and also a secondary topic, if applicable. The environmental articles published in 2019 to 2020 include 76 governance articles, 33 climate change articles, 25 water articles, 25 land use articles, 24 energy articles, 16 natural resource articles, 16 wildlife articles, 5 air articles, 2 toxic substance articles, and 2 waste articles. You can see each grouped by percentages here. We also gathered data about article subtopics, mainly because the governance category casts a wide net with 36 different subcategories. This chart tracks the exact same data but combines governance subtopics that comprised less than 4% of our results. The most common topic within governance and articles was environmental law, policy, and governance, then administrative law tied with international law, and private governance followed by state governance, and finally, environmental justice coming in a close 6th. Out of our top 20 articles chosen for 2019-2020, 10 were from environmental law journals and 10 were from general law reviews. Within this top 20, we had a range of primary topics, with the most common being governance, climate change, and then energy. You can see the secondary topics as well, although not every article had a secondary topic. In our top 20 articles, 6 articles called for action by state and local governments as part of their proposal. 6 called for action by other federal executive agencies or judicial actors. 2 articles called for updates to federal or international law, and 6 articles proposed private governance measures. We had a great pool of articles to choose from this year, and we are excited to discuss some of them with you today. With that, I will hand it back to Professor Breggin.
Thank you both. Really terrific job. I've so enjoyed working with both of you this year. And I also want to just send a special hello out and thank you to all the LPAR students who are participating today and are watching, well, not just in Nashville, but around the country, because we've been virtual for a lot of the semester. You guys really rose to the challenge this year and managed to stay engaged and just really did an incredible job of picking this great group of articles. Before we start, I also just want to make sure to thank our Environmental Law Institute All-Star Research Associate, Heather Ludke, for her incredible work this year at LPAR. She really hit the ground running and couldn't have done it without her. And thank you to Colin Gibson-Tansel, who's managing the technology for us today. Needless to say, his job has not been easy during the pandemic as all of ELI's convenings have moved online. And I also really want to thank Victoria Dorwood, who is with Vanderbilt and has also been incredibly helpful with LPAR. So my job today is to move us along as smoothly as possible, but very deliberately, so we make sure we aren't talking over each other and staying on time. The way this is going to work is that the Vanderbilt Law Student article editor will introduce the panel, and then the professor or professors will present the article for about 15 minutes, and each panelist will comment for about 10 minutes. We'll give the professor a chance to respond to what he or she has heard from the commenters, and then we will turn to the student articles editor to pose the first question for the panel, and then we'll take questions from the audience and continue the discussion among panelists. We encourage you to ask questions as they arise during the panels. Please don't wait till the very end to do so. Just use the question box and go to webinar, and I'll pose as many of your questions as I can during the Q&A at the end of the panel. A quick word about technology and more importantly, patience. As we change panels, we apparently cannot mute the audio. So unfortunately, you're going to hear us testing the tech for each new panel while the conference is on a 10-minute break. All you attendees are muted, so you're of course free to come and go throughout the day through the panels. You can just re-enter the webinar using the same link that you used this morning. Lastly, if you have any problems or concerns during the day, please feel free to write them in the GoToWebinar question box. Only the conference organizers are getting that, and Heather and Colin can help you out. Finally, the slides from the presentations will be posted on the LPAR website. The slides will be posted as well as the speaker bios. We really can't do justice in our introductions for the panel members, so their full bios are available online. We will be tweeting during the conference, so please feel free to engage with us on social media. We are at ELI.org. I can't even believe I'm saying that. Like, I've gotten so savvy on the social media. So I'm going to hand it over to Vanderbilt third-year law student Nathan Campbell to introduce our first panel. Thank you again for joining us today.
Excellent. Thank you so much. So my name is Nathan Campbell, and I'm a 3L at Vanderbilt and an articles editor for LPAR, and I'm here to introduce our first article, which is the Law and Science of Climate Change Attribution, which is by Michael Berger, Jessica Wentz, and Radley Horton. Michael Berger is the executive director of the Sabin Center for Climate Change Law and a senior research fellow at Columbia Law School. He is also of counsel at the environmental law firm Schredling. He is a graduate of Columbia Law School and of Brown University, and holds a Master's of Fine Arts degree in creative writing from NYU. Jessica Wentz is a non-resident senior fellow at Columbia Law School's Sabin Center for Climate Change Law, Jessica previously worked as a visiting associate professor and environmental program fellow at the George Washington University Law School, where she received an LLM in energy and environmental law. She also has a JD from Columbia Law School and a BA in International Development from the University of California, Los Angeles. Hadley Horton is a research professor at Columbia University's Earth Observatory. He is the lead principal investigator for the NOAA Regional Integrated Sciences and Assessments Funded Consortium for Climate Risk in the Urban Northeast. Hadley also teaches in Columbia University's Sustainable Development Department. In addition, we have three esteemed analysts. First, we have Steve Goldstein, who is a Special Assistant Attorney General in the Office of the Attorney General of Maryland and an NYU State Impacts Center Fellow. Before joining the Maryland Attorney General's office, Steve worked for the Defenders of Wildlife and the Sierra Club in Washington, D.C. Steve holds a JD from the Georgetown University Law Center and a Master of Public Policy from the University of Maryland. We also have Joanne Spalding, who is a Deputy Legal Director and Chief Climate Counsel at the Sierra Club, where she has worked for over 20 years. She directs the Sierra Club's federal and state climate litigation and regulatory work. She formerly worked in private practice representing labor unions in environmental cases. She received her BA with honors from Northwestern University and her JD from the University of California, Hastings, and she also clerked for the Honorable Melvin Brunetti of the Ninth Circuit. And finally, we have Stacey Van Belleghem, who is a partner in the Washington D.C. office of Hatham & Watkins. She represents clients in a variety of industry sectors, including major project infrastructure and development and administrative petitions and rulemaking and litigation under federal environmental law. Before becoming an attorney, she worked at the National Trust for Historic Preservation and also at the National Park Service. And with that, I will turn it over to our authors.
Okay, thanks everybody. I'm Bradley Horton, and I'll take it away here. Heather, if we could actually advance to slide 8 to kick things off, if that's possible. Thank you. So I'm going to launch us into some of the science that kicks off our piece before turning it over to Mike to talk about broader legal and policy implications. So most fundamentally, as a climate scientist, when we're trying to project what may happen in the future, but also look at historical trends, there are some very fundamental terms to grapple with at the very beginning. First of all, the notion of detection. Have we observed trends, for example, in temperature, sea level, or rainfall that depart from what we might expect to happen due to chance alone? So detection is basically the idea that if we look at a period of time, say 30 years, is it unusual, say the extent to which we may have seen an increase in a variable relative to what we might get due to just random chance alone? So that's the first principle. But really for trying to attribute and understand the causes of changes, that's a more complex issue, because if we're actually going to get to causation to say, not only did temperatures rise, but among an array of possible drivers, we're able to say, this is the one that caused that, is a higher burden of proof, if you will. And the science of attribution is related to trying to detect those drivers in the past, which is of course very useful information as we try to predict the future. So fundamentally, in climate attribution, a lot of what we're doing is not those projections. What is the sea level going to do over the next 100 years? But rather instead, it's when we look at recent events, some extreme heat wave or heavy rain event, can we use tools like climate models run over a historical period, run in the past, to see how greenhouse gases that we have put in the atmosphere, for example, have already changed the statistics, loaded the dice towards perhaps more frequent extreme events. So we might use, so just to give an example, Hurricane Harvey leads to a huge amount of rainfall in a certain region. We could run an identical climate model through 2 different historical experiments. One where we kept greenhouse gas concentrations at the levels of, say, 50 or 100 years ago, when they might be 40% lower. Run that simulation out for 100 years, and then do an identical simulation starting whatever it was 50 or 100 years ago with those lower greenhouse gas concentration levels, but instead each year marching the greenhouse gas concentrations up so they matched what we actually put into the atmosphere over the last 50 or 100 years. By comparing the statistics from those 2 climate model runs, if we see more heat waves of a certain magnitude in one of the runs than the other, we can begin to say, okay, climate change and specifically human activities like burning of fossil fuel have made that type of event so much more likely than it might have been in the past. That's sort of the fundamental science behind climate attribution. So we can go to the next slide. We talk about several categories, a sort of typology of thinking about attribution. So most fundamentally have, say, fossil fuel emissions or changes in aerosols had an impact on our average climate, global temperature, global sea level. Often of more interest in something I'll delve into more detail on, impact attribution. So getting beyond the climate system to say, for example, how is an ecosystem affected? What are the economic damages occurring in extreme events? As I'll show, the science is a little trickier to attribute those impacts to, say, fossil fuel emissions, because we're going a little further down the chain. We're having to first say, did climate change, human activities cause warming? Did that warming maybe impact extreme events? Did those extreme events, such as a heavy rain event, lead to the damages, such as more flooding on the ground? So as we go more steps down the chain, there's more room for other drivers. So it gets more challenging, although it's also potentially much more impactful if we can say that those economic damages are attributable to say, a certain fossil fuel emitter. So you can see these other categories here. There's also source attribution, very exciting advances in that area, being able to go back through history and look at emissions from certain sectors, industries, countries, individual companies, and say how much, say, of the warming to date or the sea level rise to date can be attributed to individual entities. Okay, so next slide. We don't have time to go through each of these, but we'll just hone in a little bit on one of the categories. Impact attribution, which I mentioned earlier. These are some of the types of impacts that are, highly relevant, as you all will know. You see things like wildfires front and center these days. But all these categories, not all of them human-centric, and some of them clearly, integrating a variety of factors, of which climate is only one. So that's part of why it gets so complicated. Okay, next slide. All right, just to give a little bit of a sense of some of the tools that climate scientists and other types of scientists use in doing this work. Observational data, critically important. So for example, how do we know exactly what the temperature was in a remote area? How do we know how locally a rainfall event might have happened? But that observational data is really critical to help us say, even before you invoke climate change, just how rare, just how common was a certain event. Is an important and sometimes non-trivial question. Physical understanding is really important. There's so much that we have learned over time. It's trivially simple, trivially clear that greenhouse gases do warm the planet. The basic physics have been understood for 200 years now, and a whole bunch of lines of evidence have come together to reinforce those hypotheses. So we start with some particular intuition, tools, and physical understanding that stands on generations of advances in this work too. There's statistical analyses I don't really have time to get into that can play a part. And then those climate models and other types of models that I mentioned earlier, very important for allowing us to test different hypotheses. We only got one iteration, one running, if you will, of the actual world over, say, the last 100 years. The truth is there are other possible configurations. And using climate models can allow us to test some of those alternate hypotheses in addition to letting us project the future. So we can go to the next slide just to briefly unpack a few of the uncertainties that we just described. Observations are of different quality and length over different parts of the world. There haven't been as many attribution studies, for example, over large parts of Africa, parts of the Amazon, Southeast Asia, just to name a few places. Part of the reason is a lack of robust observational data at fine scales today, but then also not having a long enough historical record to make broader suppositions about how rare some of those events would be naturally. So I mentioned in attribution, we have to unpack different potential drivers. One source of potential drivers is just natural variability. We can't just say this data set has gone up over the last 100 years and must be due to fossil fuel emissions, because in some cases there's random, unpredictable variability, maybe tied to ocean circulation. We have to be able to unpack, and models are very helpful for this, different drivers. Greenhouse gases weren't the only engine influencing climate over the last 100 years. We've also had volcanic eruptions at times, aerosol emissions, small particles, just to give a few other examples. So we have to unpack under this sort of different dials, sometimes with different forcings, to be able to isolate, say, the effect of those human and fossil fuel emissions. And then always issues of spatial and temporal scale. A small cloud burst, a local rain event may have a very big impact. Climate models can't necessarily operate at those scales, so we have to rely on other tools to think about that. Okay, next slide. Before I turn it over to my colleague, Mike, just to, if we could advance to the next slide. Some of the things that have been happening, we've seen attribution moving to new data sets. For example, looking at multiple variables at the same time, realizing a fire is not just due to drier conditions, it's also heat maybe at the same time. How do we do attribution across multiple variables? You see attribution now in real time, so that as soon as an event happens, sometimes even before an event, studies that are able to detect a human role. And there's always new sources of data. Now we do what we call paleoclimate data. We can go back and look at tree rings and get a more robust sense of just how rare events are today. And don't have time to get into it, but source attribution Individual fossil fuel majors, for example, some of their emissions can increasingly be linked to actual climate impacts around the world. My last slide coming up is talking a little bit about areas where there are real challenges and thinking about the future. Incomplete alignment between what's needed by the legal and policy community and what the science is able to provide. And a lot of thought now about dealing with non-linearities. We love to think these systems are linear, but the truth is one unit of emissions in the past may have had a fairly linear effect. We could be approaching a point in physical systems and social systems where that next same unit of emissions could have a nonlinear cascading impact. Look at some of the unpredictable things we saw with COVID. These systems aren't linear. How do we integrate that thinking into these issues is a big question. The last slide before I turn to Mike describes a database that we've put together. People can just go to this to learn a little more. It's really just an aggregation of studies that we think in this detection attribution space have high relevance for law and policy salience. So thank you. With that, I'll turn it over to Mike, who's going to give us a much broader context, legal policy dimensions of this work, and some climate change issues that even go beyond detection and attribution. Thanks.
Great, thank you so much, Radley. And thanks to Vanderbilt faculty and students who put this issue together and ELI for convening this event. It's really an honor to be included among the other authors. And I'm very much looking forward to hearing what the commenters have to say. Just to take a quick step back, as I'm sure most on this webinar are well aware, we are not on track either in existing policies or in existing global pledges to reduce emissions consistent with a 2-degree global warming pathway, far less a 1.5-degree global pathway. This emissions gap can also be thought of as a policy gap, and in order to fill that policy gap, individuals, community groups, environmental organizations, subnational governments, corporations, and others have turned to the courts in the United States and in courts and international fora around the world. Next slide, please. One of the things that we do at the Sabin Center, of course, is track this litigation, and we have 2 databases, our climate change litigation databases that keep tabs on climate cases around the world. The cases that we include in this database, to be clear, are cases where climate change is a material issue of law or fact. Which means that there are many cases that have high salience for climate change that are not included. And you can think about the Beyond Coal campaign as sort of a poster child for those cases which are clearly going to have major climate impacts in aiming to shut down coal-fired power plants, but do not put climate change front and center either as a material issue of law or fact in the case, and they're not included in this. So there is this emerging field of study around climate change litigation. People have been looking at climate cases for a while, but there's an increasingly global scope both to the cases themselves as well as to the studies. And there are some recent studies that look at the Asia Pacific region, that look at Australia, that look at South America as venues for international climate change litigation. But nonetheless, the vast majority of cases that we've tracked are in the United States. And that's by an order of magnitude more than in other jurisdictions. The next closest after the United States is Australia, and that's literally 10 times less in terms of the sheer quantity of cases. You can go to the next slide. Now, this is a gross oversimplification of cases, but in order to look at the relationship between attribution science and climate litigation, and to a lesser extent policy, we decided to categorize the cases that we've seen. And so there's more than 1,700 cases around the world, and obviously there's a tremendous variety, but you can boil it down in one framework to cases against governments for failure to control emissions, cases against private actors seeking to hold them accountable for their contributions to the climate change problem, industry lawsuits that are actually challenging government policies aimed at controlling emissions or adaptation actions. And then sort of a large group of cases that focus on climate change impacts, on adaptation, on risk disclosures, that don't target so much addressing the emissions problem as addressing the wide variety of other problems that go along with climate change impacts. Next slide. Now, I should say that the vast majority of these cases are cases that fall under what I tend to think of as sort of conventional or traditional environmental, natural resources, energy, or land use law. In the United States, we've looked at climate cases and found that some 75% of cases happen under NEPA, the Endangered Species Act, the Clean Air Act. That being said, some of the cases that are most visible, both in the public consciousness and in media representations and in the scholarship, are the small number of cases that focus on sort of big ticket theories like public nuisance and holding individual companies liable for their contributions to climate change, or human rights-based cases that seek to hold governments accountable for their failure to regulate on a pathway commensurate with or consistent with a 2-degree or 1.5-degree pathway. Those are a very small number of cases altogether, but they do sort of have an outsized potential impact as well as an outsized sort of role in the public imagination. Now, again, this is a gross oversimplification, but in looking at those categories of cases, we chose to focus on 4 key areas or legal issues where science is particularly salient. This would be standing, justiciability, the question of whether climate cases raise political questions and properly fall within a court's domain. The key questions of causation, which happen not just in emissions-related cases, but also in cases seeking to create that or identify that key causal link between a particular impact, say a change in a endangered species habitat, and global climate change. And then eventually apportionment. How do you go about sort of apportioning responsibility or liability to these different actors? Next slide. So this is a repeat of the slide that Radley showed. In looking at those key legal questions, we looked at these categories of detection and attribution research. Next slide. This will be sort of where I close. You know, in looking at these categories of cases and looking at these legal issues, one thing that is clear is that no court that we've been able to identify has seriously challenged the basic fundamental science of climate change. And now, even now, in the big high visibility cases, you see everybody conceding that climate change, anthropogenic climate change, is real. But the devil is in the details. And there are a lot of details when it comes to these issues. So we identified a few areas, and Radley sort of touched on this at the end of his portion, key areas where there are challenges for litigants and where the science may need or could benefit from some improvement. So there is a need for increasing quantities and complexity of research on those impacts and changes that have the greatest impact on vulnerability, on vulnerable communities, as well as on potential plaintiffs. Now, there are a number of complexities that might arise in seeking to have studies done for particular cases, but the need for greater global coverage, for increasing amount of scientific attention in areas that are as yet understudied, and that does include global communities which are highly vulnerable to climate change, could have a significant impact on litigation moving forward. Source attribution studies. So plaintiffs could benefit in their cases, and defendants may need to contend with and counter these end-to-end attribution studies, which look at not just quantifying the amount of contribution that a corporation, an industry, or a country makes to climate change as a global phenomenon, but then to a particular impact. Sea level rise in a particular place, increased extreme event activity in a particular location. Confidence levels. It would be helpful to have more studies that look both at the high probability low ball estimates as well as the low probability high ball estimates, meaning those cases, those impacts that are high probability of occurring, but are relatively low level impacts, and then those extraordinary impacts, those kind of getting close to the tipping point type of impacts that may have a lower probability, but because they are a higher risk, ultimately warrant increasing some more attention. And then finally, accessibility. Studies and results need to be communicated in straightforward language by the scientists and then accurately summarized for non-scientists, whether this be in a litigation context, whether it be in a political context, whether it be in a public education context, whatever it be. There's a great awareness now of the need for science communication and the benefits of science communication. And as all the lawyers on this call know, and the law students either know or will learn, the ability to communicate that science effectively in plain language is key to success, whichever position you're arguing. So I think that that's the end of our presentation. You can jump to the last slide, I think, for our contact information. And with that, I am very much looking forward to hearing from our commenters. Thanks so much.
Great, thank you, Mike and Radley. So interesting. I want to remind everyone to send in questions. We already have some great questions, but send them as you think of them. And we're going to turn to our first commenter, Steve Goldstein.
Okay. Hi, everyone. And, first of all, I'd just like to thank Linda and all of the law students at Vanderbilt that helped put this event together. I know it's been a very difficult year for a lot of us, and really it's kind of remarkable that it's all come together this well. I'd also say I'm extremely flattered to be on this panel. I found the professor's article just a really excellent read and a tremendous resource for thinking about the issues of climate attribution and a lot of the issues that come up in climate litigation moving forward. Before I start, I'd just like to remind everyone that everything that I'm saying today and any of the information in these slides is just from my own personal opinion and doesn't reflect the positions of the Attorney General's Office of Maryland or the NYU State Impact Center either. So understanding that we have limited time, I guess I should dive right in. So one aspect of climate litigation that I find particularly interesting is the attempts that we're seeing now by states and some municipal plaintiffs as well to hold fossil fuel companies accountable for their alleged market misconduct over the past 5, 6, 7 decades. We can go to the next slide, Heather. Thanks. So what am I talking about when I talk about this type of corporate malfeasance? Well, we're talking about the concept that the fossil fuel companies really were some of the first to understand that, burning fossil fuels and emitting greenhouse gases had a significant impact or had the potential to have a significant impact on Earth's climate systems. As early as the 1950s, some of the first studies were conducted by scientists working for Exxon and for the API, the American Petroleum Institute, on those issues. And the results of those studies were further developed and confirmed going through the 80s. But rather than disclose this information to the public and really have, the conversation that we needed to have about, the benefits and costs of continuing to use these products, the fossil fuel industry kept this information to itself. And then once public sentiment began to emerge and public awareness of the issue began to take hold, they started to conduct a massive campaign to diminish public sentiment and public action against climate change. And that really had kind of these 3 main points that we saw. The first is that, there were public statements made, on TV and commercials and in a lot of newspaper editorials that said, we need more information, more research, more studies. Climate change is not a known phenomenon, and the human contribution to it is far from certainty, when in fact, the board members of these companies were being told the exact opposite. We also had efforts by these companies to fund scientific studies with predetermined results that would draw, some that would misrepresent the state of climate science and the consensus that was emerging around those issues. And then we also have funding of third parties to push this anti-science agenda. Now, at the same time, and maybe a little bit later, we see that as climate change becomes a leading concern of consumers, the fossil fuel companies begin to attempt to market themselves as having a more environmentally beneficial portfolio than they actually do, saying that they are part of the solution and not necessarily part of the problem. We can move on to the next slide, please. Thanks. So what's the issue with this? Well, it diminishes public will to actually address climate change, and it harms the abilities of markets to adapt to address the problem. All in all, in the end, there's a strong correlation between the public sentiment to actually, use their wallets to affect policy change and the level of fossil fuel emissions, greenhouse gas emissions that ended up occurring. Next slide, sorry. Okay, so, one of the things that's interesting is that, we have this industry-wide and society-wide campaign of deception and disinformation. And it raises a couple of questions. The main one of those is, well, what can we do about it? And I think it's important to keep in mind that in a lot of states, there is strong precedent for combating these types of issues. I'll start with the second one that's on the slide here. Greenwashing, the false or misleading claims about the environmental benefits or the lack of environmental harm that a product produces, those are, traditionally met by state enforcement officers, most often the attorney generals, or in some cases, private citizens that are empowered by state consumer protection laws to bring private claims. And those are things that state AG's offices have been addressing for the past 20, 30 years. Now, on a broader scale, the analogy or the parallel here would be to the tobacco litigation and the conduct of the tobacco industry starting in the 1950s, really when tobacco scientists working for the tobacco companies became aware that the products they were distributing had serious human health impacts, and yet the tobacco companies, undertook organized campaigns to not only withhold that information, but to continue to double down on the fact that their products were beneficial. They were things that people wanted to buy. They didn't actually cause the human health issues that were claimed. Now, in time, the litigation over, tobacco injuries evolved from just the personal injury claims of individual plaintiffs and even class actions to claims from being brought by the states to try to recover for the excessive costs that tobacco-related injuries were causing on their Medicaid and Medicare payments. And eventually, that's what resulted in successful litigation and the large-scale master settlement agreement, which has had varying results in effectiveness. We can move on to the next slide, please. Okay, so state suits against the fossil fuel companies. You may be most familiar with these from the recent questions that were up in front of the Supreme Court along the lines of removal review by appellate courts over state causes of actions that the fossil fuel companies attempted to bring into the federal judiciary. But there have been a handful of cases brought by states and municipal actors alleging violations of unfair and deceptive trade practices legislation or consumer protection acts to try and hold the fossil fuel companies accountable for this alleged, multi-decade campaign of deception and disinformation. Some of these cases include common law claims for trespass and nuisance, which is an interesting aspect, but others focus exclusively on the marketing practices and the alleged disinformation campaigns of the fossil fuel companies. We can go on to the next slide. So I thought that it was interesting, or it would be interesting to take a look at where exactly attribution science fits into those claims of violations for the consumer protection laws and these statutory violations in the states. It seems pretty clear that it's less of a burden at the standing and justiciability stages of litigation, but that the need to still link ultimately the expenses that states are paying to recover from extreme weather events, to insulate communities from the effects of climate change. These will still be issues that require, in some way, shape, or form, relying on attribution type studies. So at the end of the day, I think it's an interesting set of claims, and it'll be an interesting thing to watch to see how attribution science continues to play a role in this type of litigation. All right, so thanks, Linda. I'll hand it back to you.
Great. Thank you so much for those great comments. And we are going to go over to Joanne Spalding now, who had to get up terribly early to do this. So thank you for being with us.
Thanks, Linda. And I want to thank ELI and especially the students at Vanderbilt for all the work that they've put into this conference. And thanks to the authors for their excellent article. The law and science of climate change attribution is a valuable tool for the times when science of every kind is under attack. Environmentalism is grounded in science, and environmental lawyers of every stripe depend on scientists. Whether it's wildlife biologists or hydrogeologists or climatologists, scientists are the ones who identify, describe, assess, and solve environmental problems. For climate change in particular, where the effects are so far removed from their causes and the connections are far from intuitive, attribution science must be the starting point for establishing priorities and developing strategies to mitigate and adapt to climate change. So I'm going to give a few observations from the perspective of the environmental litigator. For environmental NGOs, as we've turned to addressing climate change in the last couple of decades, it's been essential for us to establish priorities. That's where source attribution research has historically been important, and the more refined it is, the more we can do with it. We started out trying to reduce greenhouse gas emissions from vehicles, and most of our lawsuits that are beyond coal campaign lawsuits that Michael was referring to earlier, most have been lawsuits against government entities to try and require reductions in greenhouse gas emissions. So of course we looked to vehicles first and power plants, and then we looked at what is the next category. So we looked at oil and gas emissions from methane, as we're looking at what sources in the U.S. I'm focused on are contributing the most to just really looking basically at their level of emissions. But that can be complicated because you look at something like methane from oil and gas, there's so many different sources. There's a question of what is the global warming potential of methane? Do you look at the 20-year potential or do you look at the 100-year potential? So there are many questions that need to be answered as you look at those priorities. And even smaller categories of sources in the US are significant by global standards. For example, source attribution data shows that methane from US landfills alone is greater than the total greenhouse gas emissions from 3/4 of the world's nations, but it's only 1.7% of US greenhouse gas emissions. So while we've started with the largest source categories, we need to get to the smaller ones to reach net zero by 2050. That's why so we recently filed a lawsuit challenging what's known as the significant contribution rule that was a midnight rule of the Trump administration. And that rule, the DC Circuit just issued a decision on Monday, actually, fortunately, vacating that rule and remanding it to EPA. But just to say why that rule was such a problem, it would have prevented EPA from regulating any stationary source category less than 3% of US emissions. But as that landfill example I just gave shows, or if you look at refineries, they're even bigger. That's more, something like 4/5 of the countries in this world have emissions that are lower than just the refineries in this country. But EPA's rule would have not enabled us to get to any sources, or to EPA to regulate any sources other than power plants, or I should say stationary sources. It did not affect mobile sources. So I'm going to move on to a few comments on standing, because of course climate change litigation starts with standing. As the authors explain, climate impact attribution studies provide evidence that's essential to establish standing based on climate change. Those studies, the more detailed, accessible, and localized they are, the better it is for those purposes. So it's been helpful to include studies on climate change standing in our litigation, but because the courts are so skeptical of standing based on climate change, the safest route for us has been to hedge our bets by alleging procedural injuries, other environmental harms, such as harms that the activity might cause to species, or harms from co-pollutants, so like conventional pollutants in particular. So, and then another strategy that we engage in as an NGO is to partner with states who have a lower bar to demonstrating standing. There is a hopeful case that came out a while back, NRDC versus Wheeler in the DC Circuit, that found that NRDC had standing to challenge the EPA's rule that would have reduced regarding regulation of HFCs. And the court found standing there based on members who owned coastal property that where there was attribution science showing that coastal property was especially vulnerable to climate change. And in that case, NRDC supported their standing with detailed expert declarations describing emissions increases and the impact of climate change on specific areas where their members lived. So it is, as I said, we have managed to establish standing based on climate change, but it is a big challenge because of the number of sources, the requirement that the Supreme Court has imposed that the sources are a meaningful contribution to global emissions, and the ability to try and show that any given member of our organizations is affected by those emissions. And the last thing I want to talk about is just a little bit about using climate impact attribution studies to direct resources. Climate change, of course, is happening, the impacts are occurring, and they are worsening. And the adapting to that will require substantial public investment in infrastructure. But the question is, where do you direct those resources? So in President Biden's executive order on climate change, or one of them, he states that 40% of the benefits should flow to disadvantaged communities. So for spending to address climate change, 40% of those benefits should flow to those communities. So the question is, how do you identify those communities? What does that mean? Well, of course, you can look at whether it's a low-income community, whether it's overburdened by other types of air pollutants. But one of the things that is important for adaptation purposes is to identify those low-income and minority communities that are especially vulnerable to climate change, to steer those investments. And an obvious example is Houston and industrial, looking at places where there are industrial areas where there's hurricanes or flooding that affect the neighboring communities. So the benefit of researching that, looking at those communities and having climate attribution research that can actually look at the impacts, is that historically, when we have disaster relief payments, for instance, or any sort of adaptation infrastructure investments, they tend to go to the wealthier and the whiter areas. They have more political power, and especially there's some perverse incentives when there's disaster relief where people whose property is more valuable just get more money out of FEMA and other disaster relief programs. So by identifying those communities and using some policies like President Biden's order on 40% of benefits flowing to disadvantaged communities, we can really ensure that some of our investments go to the communities that need it most. And with that, I will pass it on. Thank you very much.
Thanks so much, Joanne. As just a reminder to send in questions, and we are going to hand it over to Stacy.
Great, thank you so much. And again, like my panelists, I'd like to thank ELI for including me in this panel, in this wonderful event, and thank the authors for their very helpful article. And I'll say that as a lawyer, I always appreciate articles like this that help me understand the science, and I think you did a really good job of laying it out. And I also just want to acknowledge at the outset that my remarks today are, me speaking on behalf of myself. I don't speak on behalf of my firm or any of my clients. So the data before us from the 4th National Climate Assessment regarding increased global air temperature and sea level rise is stark. And the assessment's modeled future projections are even grimmer. In my opinion, we need meaningful and swift action to slow and halt greenhouse gas emissions and the resulting impacts of climate change. In addition to reducing our emissions, we have to take strategic steps to prepare and adapt our infrastructure, our processes, our cities to the changes that will come. And I believe that these actions will need to be anchored in science, in law, and in economics. And the actions are going to need to be taken by the federal and state governments, businesses, and ordinary citizens with the help and the support of academia, scientists, engineers, and many other disciplines. Observation data, modeling, and physical sciences contributed meaningfully to our current understanding of the climate change issue, and scientific understanding continues to evolve and improve in important ways. Professor Berger and his co-authors have identified, both strengths and limitations of attribution science and have raised important questions regarding potential future trends in the use of this science to support policymaking, planning, and litigation. I'm pleased to share my reactions to the paper, but first I want to put my comments in some context. So I believe that stabilizing greenhouse gas concentrations in the atmosphere will require the continued transformation of our energy, transportation, and manufacturing sectors. The transformation is going to need to harmonize multiple national priorities, including economic growth, energy and transportation reliability and affordability, national security, competitiveness of our businesses, and of course, the important factor of significant environmental performance. Achieving these goals are going to require public and private sector innovation, public and private sector investment, and large-scale deployment of clean energy technologies. And it's going to hinge on the engagement and the leadership of multiple federal, state departments, agencies, coordinating with one another according to their respective expertise and their jurisdiction. Greenhouse gases, present a unique regulatory challenge, and this is, I think echoing what Joanne shared, in that, they're global rather than localized or regional, and they come from, both mobile and stationary sources of every size, which I think is very unique from a regulatory perspective. As the authors acknowledge, climate change is the effect of multiple different greenhouse gases and also other forcing agents, and all of these inputs result in different effects. So I wanted to provide that background because all of these factors lead to very challenging policy questions about who is responsible for the effects of emissions and where to really focus and prioritize our policies and our investment to reduce emissions. So given these many critical considerations and challenges, I believe that the comprehensive effort that's really needed to achieve meaningful reductions in greenhouse gases in the United States should be accomplished by congressional action in combination with comprehensive executive action. And so then my comments that follow are really offered in the context of those views. So let me start with policymaking and planning. Given all this complexity and the comprehensive nature of what I just described regarding the transformation, particularly the complexity of congressional and federal agency action, I think attribution science could really aid policymakers and planners in assessing where to prioritize federal infrastructure investments, which incentives should be enacted to speed up the transition to a carbon-free economy, and the nature and the stringency of regulatory restrictions that would be necessary to achieve greenhouse gas reduction goals. However, I think there's some important considerations for using attribution science in this policymaking and planning context. The first is that I think policymakers really need to establish clear rules of the road at the outset. So as the authors note, the physical sciences alone can't fully answer the question of who's responsible for the emissions, because responsible could really be apportioned in so many different ways. So if policymakers use attribution science to influence their decision making, they really need to develop these reasonable attribution rules and parameters that reflect deliberate policy decisions regarding how emissions and impact should be attributed. They need to take into account the important balance of considerations that I previously noted: the economic growth, energy and transportation, reliability, competitiveness of US businesses, and the environmental performance. Second, I think policymakers and planners should recognize limitations in the science and areas for improvement. So in relying upon attribution science and in developing these rules of the road, I think policymakers need to take into account the uncertainties in predictive tools and other limitations of the science. The authors acknowledge and list a number of potential data gaps, uncertainties related to the models, uncertainty in observation measurements, difficulty of isolating internal climate variability, the challenges of the models predicting relative contribution of multiple anthropogenic and natural forces. And so I think all of these limitations need to be acknowledged and accounted for in policymaking if the science is used in this context. One of the recommendations that the authors make is that scientists utilize confidence levels in their research, and I think that accurate confidence levels can really be useful to signal to lawmakers the strengths and limitations of particular research. And then I think that we should continue to strive for advances and improvements in the sciences, as the authors note, and in particular improvements in how to communicate it in a clear way that would be helpful to lawmakers. So now let's turn to litigation and the implications of using attribution science in the tort and other litigation contexts. And here I'd like to note that I'm really kind of focused on tort litigation. I want to distinguish that from, for instance, administrative record review, where a court is reviewing an agency's use of science and making a decision making, which is a very different context. But in the tort context, the authors acknowledge limitations and concerns regarding, the conflicts between, using attribution science and tort laws. And from my perspective, I think that the limitations really can't be underestimated. In my view, the concerns regarding the use of attribution science in the tort context are significant. I think tort law in particular is uniquely ill-equipped to accommodate attribution science or predictive modeling that seeks to tie specific climate change impacts and damage to a particular actor. I think there are multiple disconnects between attribution science and the standard of proof in tort litigation, and the uncertainties and the limitations of modeling, prediction, simulation. They raise significant problems in the context. I think the breaks in the chain of causation are many. The uncertainties and limitations of these predictive tools are at odds with the standard of proof. But importantly, I think the question of responsibility, which is really at the heart of attributing these specific harms to actors, is a policy question. The attribution aspect really raises significant problems in the tort context. There are government actors who permitted the activities that led to the emissions. There are manufacturers, distributors, suppliers who contributed. You have individual consumers who directly emitted or indirectly generated greenhouse gases. And the use of attribution science in litigation to try to assert that one or multiple of these actors cause certain impacts, in my view, isn't appropriate. I think it would stretch legal duty and breach a reasonable conduct beyond recognition. And again, I want to note that I'm distinguishing here between the use of attribution science to seek to attribute a particular climate change harm to a particular entity in the tort litigation, which I view differently from, for instance, a court's review of an agency's reliance on climate science or modeling. That administrative record review in judicial deference to the expert agency opinion is a very much, very different context. So as I noted at the outset, I think legislation and policy are really necessary to affect change. I think attribution science may best serve efforts in that area. I think we have collective responsibility for climate change, and collective action is really needed to address it. Questions of attribution of who should be responsible for mitigation and efforts to halt the effects of climate change are policy questions for elected and appointed officials who craft our laws and who make the regulations that are going to tackle the problem. The limitations of attribution science are incongruent with the elements of proof and causation in tort litigation. So I think science, can and should play a meaningful role in important legislative and regulatory initiatives. And again, in considering attribution science in this context, I think it would be helpful for decision makers to really think about focusing their efforts on developing these rules of the road and thinking about how to account for uncertainties and gaps in the science moving forward. So Linda, I'll turn it back to you.
Thank you, Stacy. Well, thank you to all the commenters. And I suspect that our authors have a few things that they would like to say in response to what they've heard. We had hoped that your other co-author, Jessica Wentz, could join us for this part, but unfortunately, I think she is not feeling well. So we will hand it over to the two of you for sort of a 5-minute response to some of the observations that you heard.
Great. And Jessica does send her regrets. She was really hoping to make it to participate in the event. Thank you all so much for your comments. Really interesting, really important comments, and really provocative in certain respects. So I think I have a kind of a short response or some response to each, and then I'll let Radley take over. Steve, I appreciate your focusing on those state and local cases because I can't, because I represent some of the parties in those cases. And so I do want to be clear that the comments I'm giving here today are in my role as co-author on this paper and in my role as executive director of the Sabin Center, my own views, and don't reflect on those cases or my clients' perspectives. And that will be very important, Stacy, when I come back to your comments in a little bit. The one thing, Steve, I wanted to mention in regards to the issues you brought up about balancing the equities and the statutory basis and the role of attribution science in those. I just want to flag for people on the webinar today that last week, the Second Circuit Court of Appeals did dismiss the City of New York's lawsuit against the fossil fuel companies, which pleads that the which sought to hold the fossil fuel companies accountable under a theory of public nuisance, under New York state law, and under trespass theories under New York state law. And the court's basic rationale was that these cases necessarily arise under federal common law, that there is no state common law that can apply to climate change at this level, and that the Clean Air Act has displaced any federal common law that exists under the precedent set by American Electric Power versus Connecticut, and that to the extent that the lawsuit involves international emissions, the dormant foreign preemption would preempt those claims. I think that there will be a lot of briefing in the weeks and months to come about that decision. And one of the issues that will come up is whether that decision properly understands the nature of that case and how that relates to other cases that also rely to greater extent, or in some instances, a different extent, on the promotion of the products rather than the emissions tied to the production and sale of those products. So that case is going to be a flashpoint, I think, in this question of how attribution science factors into cases focused on the promotion and then separately on the production and sales of fossil fuels. Joanne, I think your point I thought your point about the landfills and methane emissions was so spot on. And source attribution science can tell us a lot. They can show us a great deal, but they don't answer. It does not answer, as Stacy also mentioned, it doesn't answer some of these basic questions about who should be held accountable and what issues of what principles of equity or fairness or justice would require. 1.7% of domestic emissions is pretty small altogether, but when it's greater than 3/4 of the global community's individual national emissions, that sheds it and puts it in an entirely different light. And those questions about what to do with the science, what the science tells us, are legal questions and they're policy questions. And the science can help, and it can help point the way, and it has to inform those decisions, but it doesn't answer these hard questions of equity, justice, and fairness in and of itself. I also want to just touch briefly on standing, because it is such a important part. We spent a great deal of time in the paper on it, and it is one of the areas where the scientific evidentiary basis is so critical, and it is so variable in different contexts. You mentioned the sort of special solicitude offered to states under the Massachusetts versus EPA precedent, and how that's different for subnational governments and for individuals and for communities in US law, or potentially different. That's something that continues to be worked out in the courts. The NRDC versus Wheeler case was, I think, potentially game-changing. We'll see exactly how it continues to play out as litigation goes. But I think you can look at cases at the state level and the federal level, climate cases, and courts treat issues of individual harm differently. Sometimes they're given a great deal of weight. The Juliana case involved thousands of pages of expert reports, and we spend a good deal of time in the paper talking about some of these, trying to identify the particular concrete individualized impacts that individual youth plaintiffs suffer as a result of climate change in order to establish their standing to bring that lawsuit. And ultimately, the case has been decided by the Ninth Circuit, not on individual harm grounds, but on the nature of the remedy that those plaintiffs sought, which was a national plan for carbon drawdown, which the Ninth Circuit found it didn't have the authority to grant. So I think that it still does remain a question. One other interesting decision I think is pointing to on that global scale is that recently the European Court of Justice did deny a similar suit to the Juliana lawsuit, a suit brought by citizens around the European Union against the European Union, alleging that its climate plan was inadequately ambitious based on a variety of theories. And there, the court, it wasn't a US standing doctrine precisely, but if you sort of abstract it a little bit, the court found that the individuals did not have a particularized harm in the sense that it was not different from what anyone else suffers, that individuals are all, to some extent, subject to climate change, and so it was insufficient for the purposes of that case. I think that was a disappointing decision, not strictly speaking standing, but one that people might want to look at if they're interested in that. And so then finally, Stacy, again, I have to be careful in how I talk about this, because I do represent clients in some of the cases that you're talking about. The paper does not reach the conclusion that the attribution science would not support the finding of a tort duty or a tort breach, or an allocation of liability. That's not where our paper comes out. And I think that if you look at the sort of chain of causation, it's quite clear that you can trace impacts to climate change. And these can be localized impacts such as sea level rise in San Francisco Bay Area. It can be the California wildfires. It could be Hurricane Harvey. That the attribution science, whether it be slow onset changes like sea level rise or extreme events, that the evidentiary basis likely is there. It'll be a battle of the experts when it comes right down to it. But I don't think that there's any reason at this point to conclude that the science wouldn't support a judicial finding or a jury's finding that climate change was the cause of an individual extreme event or an individual localized impact. And Bradley might have more to say on that. The question of how to allocate responsibility, the source attribution part, I get your point. In an ideal world, the federal government would have enacted comprehensive climate change legislation a long time ago and would have allocated responsibility based on the science and on economic policy decision-making that's rational and well-informed, but it hasn't. And litigation has been a key tool in spurring the federal government to take action among all the agencies. And all of the agencies have pushed back at various times in different ways. Most recently for 4 years with an all-out assault on climate regulation and any, a complete and total abdication of responsibility. So, the attribution science has been key in sort of holding the line and holding the government to account, but it hasn't taken the action that's necessary. Similarly, the private sector has largely failed to take the necessary action. So while it may be true that that is what is necessary and that is what would be most efficient and that is what would be most effective, it doesn't really get us to where we need to be, which is 50% in the next 8 years reduction and then net zero by 2050. So litigation is a key tool, and I don't think that, in my view, that there's any reason at this point to conclude that tort law is inadequate to address the harms that have been suffered by the localities that are bringing these lawsuits or individuals that are seeking redress. The Yale law professor Douglas Kaiser wrote a great article about the way in which climate change pushes tort law to its limits, and ultimately concluded that tort law can accommodate that expansion. And so rather than sort of relying on my own perspective or sort of talking further about the cases, I sort of turn to that. Tort law has always expanded to respond to new challenges, and this just is perhaps the biggest instance that tort law has been forced to confront, but it's not one that it's totally unequipped to deal with. So Radley, I'll turn it over to you for any further comments that you might have.
And let me just say, we have about 10 minutes left, and I want to continue the conversation, absolutely, Radley, but I also want to give a chance for the audience to have some questions answered. So with that, over to you.
Sure, I'll try to be real brief. Just to highlight that for some climate variables, the link to human emissions is literally, as clear as some scientists have said recently, as links between smoking and cancer. And it's pretty shocking to see how just that 1 degree Celsius, 2 Fahrenheit of warming that we've had, or that 1 foot of sea level rise over the last century, which doesn't sound like much, has altered the frequency of some extreme events, heat waves, frequency of coastal flooding, by approaching an order of magnitude in some cases. So it's really open and shut for a lot of these climate variables. Where the uncertainties are more in the issue of level of precision, to what extent you can come up with a number. Is it 64%? Is it 82%? So I know those can be important issues, but I think, as Mike alluded to, for some of these climate variables and even some impacts, the direction of change and even the fact that maybe there's been several-fold increase in risk, I think is going to be indisputable. That the debate is going to be about to what extent do we need to be precise with that number. And of course, if we go to like individual locations, which is often where a case might be decided, the uncertainties do rise. But it's important to also keep in mind this broader context that many dimensions of climate change are about as clear as anything we can know in science at this place. So those are kind of dual realities that are maybe a little hard to manage in particular cases. Is Linda muted?
Not stand the question bar on GoToWebinar. It is not cooperative. I apologize. All right, we have a bunch of great questions. I know Nathan, our student editor, has a question he wanted to start off with, and then we'll go to an audience question.
There's the unmute. Okay, great. So my question about this, so as I read through the article, I kind of had two competing thoughts as I did, and the first being that for plaintiffs that bring these suits or these alignment-based suits, attribution science is kind of a newish tool for them and something that may not have been available in the past, and something that can kind of change the balance kind of there. But on the other hand, I had the worry or thought that it may turn these cases into kind of a battle of the experts that Michael referred to. And I was wondering if anybody kind of had a thoughts on whether both of those concerns are valid, or whether one is more possible than the other, or just any thoughts on that.
There was a little bit of breaking up in the question, but I think both are valid. I think that they're the science is emerging and continues to develop, and certain aspects of the science are that have particular relevance for particular kinds of cases, such as the extreme event attribution, and these end-to-end source attribution studies are very much new, and they may have particular salience for particular cases. In the judicial review of administrative action that Stacy was referring to, there have been many scientific battles, kind of battle of the experts through, not through the trial proceeding, but through sort of administrative review actions and declarations and things like that, that have already taken place. So we've already seen it to some extent. And in the Juliana case, we had it all mapped out. There were, like I said, 1,000 pages of expert reports that were laid out there to provide that battle of the experts. So there's no doubt that the science will continue to be contested in particular legal contexts, but that the trend is towards higher levels of confidence for a greater range of impacts and other variables.
Great, thank you. So let me jump to an audience question. I guess this one is really for the authors as well. What are you finding in the scientific community as to whether research agendas are being developed to address the 4 challenges you mentioned?
You want to take that one, Radley?
That's a good question. I think this is still a gap. I think it's a case where that sort of meeting point between what science is increasingly able to offer, the sort of supply side, if you will, and the demand in legal and policy dimensions. While both of those are very clear, I think it takes a lot of time to get these communities together, to get them speaking the same language, to get them listening, in both sides. So I think there's, huge room for growth. I'm not sure, how much uptake there has been yet. I think just simply as an issue of, a lot of inertia and taking time for these communities to come together. But I think it's a really fertile area where there's going to be a lot of growth in the next few years. Mike, what's your thought on that?
Yeah,
I think
that's absolutely right. I would just point to, in the event that there are any scientists on here, the Union of Concerned Scientists is pulling together a science hub for scientists interested in working on sort of developing a community of scientists with an interest in this particular intersection of their work and the law and policy fields. And you can find information about that UCS initiative on their website.
All right, I think we have time for one more question. Couldn't you flesh out data from areas that are not in the global north through investigations of traditional knowledge and local histories? Agriculturalists and pastoralists around the world know very well the typical weather patterns and how those have been changing. It is not directly comparable to data measured through scientific instruments, but traditional knowledge probably should be recognized as an important source to fill in gaps. Whoever wants to take that.
I think that's a great point. You know, I'm sure a lot of the lawyers will have interesting insights on, you know, what biases in terms of what types of information may be admissible in many instances, lack of flexibility that exists towards thinking about some of these more nuanced approaches or that may not, you know, fit in our traditional categories. Another thing that comes to mind for me is that this case of indigenous knowledge or local knowledge more generally might actually be a case where what we call impacts, for example, things like, has there ever been a fire in this region? Or has there ever been a year where a certain forest plant didn't actually produce a fruit, for example? It might actually be easier to know that over a long-term period from some of these communities than it would be to know what was the actual air temperature, the kind of things that scientists might think of as easy to know. So I think there's a lot of interesting dimensions to the question. One of them being that it might sort of turn over this thing that I mentioned and others alluded to, that impacts are harder to know. You know, maybe some of the types of knowledge mentioned by the questioner could actually elucidate in a more nuanced way impacts and the range of societal response over longer timescales. So that's a really interesting point. That's just one dimension to the question.
Yeah. So we only have 2 minutes, but I feel like the commenters didn't get to join in the Q&A very much. So I would like to just give the opportunity for like a rapid fire parting thought from any of the commenters if they would like to jump in.
Sure, I'm happy to let others go first, but just to be quick, I would say that state laws developed and been expanded to address these types of issues in the past. The tools are there, and we'll see what happens. But I think that getting the attribution science lined up really does go a long way to enabling the use of the existing tools to address an issue that has confounded policymakers for a long time at this point.
Thanks, Steve. Stacy, do you want to do a 30-second parting thought?
Sure. So I appreciate the exchange that we had, today, and I think it's everyone is in agreement. This is a very big problem with complex solutions, and as I noted, I'm optimistic about the opportunities to use attribution science in the policymaking and planning context.
Thanks, Stacy. And Joanne, you get the last word.
Thanks very much. Yeah, I too think that the developments in attribution science are really beneficial to all of the policymakers in particular. I do think they're going to be great for us litigators who will have an easier time in court establishing standing, and will also. I'm not involved in the tort cases, but I do think it's helpful in that context. But I think it's especially helpful to state and federal policymakers in the U.S. and of course in other countries as well, because there is the more refined we can science becomes, the easier it is to figure out, what are the most important sources to curtail and what are the most important places to invest in adaptation.
Well, thank you all so much for a really interesting conversation. And as you know, the written comments and a shortened version of the article will be in ELR this summer, Environmental Law Reporter in August. We are going to go on a 10-minute break. As I mentioned, unfortunately, you will be able to hear us testing the technology for the next panel, so I apologize for that. But again, thank you so much, all of you, for a terrific conversation. And we will be back in 10 minutes with the next panel.
Thanks, everyone. Great panel.
All right, well, we're going to get started. Welcome back, everyone. We're going to start our next panel, and I am going to hand it over to third-year law student, well, Carly Malone is how I know her, but she's showing up as Caroline. So over to you, Ms. Malone.
Thank you, Professor Bregan. Hi, everyone. My name is Carly Malone, and I'm a third-year law student on LPAR. And it's my pleasure to introduce the panel to discuss Professor Condon's article, Externalities and the Common Owner. Madison Condon is an associate professor of law at Boston University School of Law. Her research focuses on climate change's relationship to corporate governance, market risk, and regulation. Professor Condon's scholarship has appeared in the Washington Law Review, the Virginia Environmental Law Journal, Land Use Policy, and the Review of Environmental Economics and Policy. Before joining BU Law, Professor Condon was an attorney at New York University School of Law's Institute for Policy Integrity, where she participated in litigation against federal regulatory rollbacks. She clerked for Judge Jane Kelly of the 8th U.S. Circuit Court of Appeals and was a postdoctoral fellow with the Earth Institute at Columbia University. She has consulted for the OECD on carbon regulation and international trade law. Rick Alexander is the founder of the Shareholder Commons, a nonprofit organization seeking a shift from unbridled profit seeking to a capitalism that values only those profits that are good for the planet and its inhabitants. A graduate of Georgetown University Law Center, Rick practiced law at Morris, Nichols, Arsht, and Tunnell for 26 years and acted as the head of legal policy at B-Lab, a nonprofit dedicated to enabling people to use business as a force for good, before founding the Shareholder Commons. Among other accomplishments, Rick prepared the initial draft of both the Delaware Public Benefit Corporation legislation and the American Bar Association's Benefit Corporation white paper, and serves as a special consultant to the ABA's Corporate Laws Committee. Natasha Lamb is a co-founder and managing partner at Arjuna Capital, a sustainable investment company. Natasha integrates environmental, social, and governance factors into Arjuna's investment process while engaging major corporations to improve their performance through shareholder advocacy. Previously, Natasha was Vice President, Shareholder Advocacy and Corporate Engagement, and an equity analyst at Trillium Asset Management. She has been profiled on the cover of Bloomberg Business Week and in Forbes, Fast Company, and the Boston Globe, while her work has been featured in Rolling Stone, The Economist, The Wall Street Journal, and the New York Times, as well as on NPR and CNN. James Andrus, who is standing in for Ann Simpson today, and we're very pleased to have him, is an investment manager in board governance and sustainability at the California Public Employees Retirement System, the largest public pension system in the United States. He leads the legal and regulatory financial market agenda focused on data and corporate reporting transparency. James has been a frequent presenter on corporate governance and ESG-related topics and has testified twice before the U.S. House of Representatives. Among other appointments, James is a member of the Financial Accounting Standards Advisory Committee, which advises the Financial Accounting Standards Board on strategic and technical issues, project priorities, and other matters impacting financial accounting and reporting standards in the United States. Prior to joining CalPERS in 2014, James served as a corporate and investment management equity partner at the law firm K&L Gates, working on mergers and acquisitions. And with that, I'm excited to hear from our panel, and I'll turn it over to Professor Condon.
Can you guys hear me? Okay, great. Thank you so much for having me. I'm just really beyond honored to be here. Thank you so much to Mike Vandenberg and all of his Vanderbilt Law students. and to the Environmental Law Institute, especially Heather and Linda. Thank you so much. And really, thank you so much to the commentators who agreed to be here and agreed to respond to my article. I'm like very excited to hear from this collection of experts. It's a really great opportunity. Okay, so externalities and the common owner. So am I unable to advance the slide? That's true. So I just say next.
Yep, I'll advance them.
Okay, next. Thank you. Okay, so in recent years, many large multinational corporations have announced commitments to reduce their emissions, even committing to reaching net zero by a certain date. Shell plans to reduce its carbon footprint, including those emissions that come from the sale of its products, 20% by 2035 and 50% by 2050. Mining giant Glencore agreed to limit coal production, and Occidental Petroleum became the first US company to pledge net zero emissions by 2050. Each of these climate commitments, and many more like it, occurred as a direct result of coordinated shareholder pressure, many over strong initial objections from corporate boards and management. So the argument that I make is that these shareholders are motivated to take on the role of climate change advocates, not for any firm-specific business purpose, like trying to stay ahead of anticipated regulations, but actually in the service to their broader portfolios that are exposed to harmful climate damages. This claim challenges two key assumptions of corporate governance. The first is that shareholders homogeneously desire the maximization of share value. And the second is that institutional investors fail to monitor and intervene in corporate management due to collective action failures. So first, I'll show how and why I think this is happening, the outcomes being pursued by investors, and why it's in their rational best interest to press for emissions reductions. Next, I'll apply my argument to the broader debate about the other inter-firm effects of common ownership, which is the name for the phenomenon of many companies within an industry sharing the same large shareholders, which allegedly leads to anti-competitive effects. Finally, I'll discuss some of the corporate governance and other implications of this portfolio maximizing perspective. So next slide. The most prominent voice in shareholder climate advocacy is the group Climate Action 100+. It's a coalition of nearly 600 institutional investors that control a combined $54 trillion in assets. That's about 1/6 of total global wealth. Because of the embrace of modern portfolio theory, most of these investment funds are broadly diversified across the economy. Most of them follow an indexing or quasi-indexing approach to investment. Now, diversified funds are unconcerned about firm-specific and idiosyncratic risk. They are, however, exposed to systemic risks that cannot be diversified away. So next slide. And these characteristics lead investors to care about climate change mitigation for three different reasons. The first is to reduce harmful climate damage externalities that are imposed on their portfolio by the fossil producing and consuming firms that they themselves own. The second is to reduce portfolio exposure to systemic climate risks. And the third is to preempt government intervention by self-regulating rather than lose portfolio value to some sort of regulatory mechanism like a carbon tax. Next slide. So I'm arguing that the reason that Larry Fink of BlackRock, or our guest from CalPERS, for example, is pressuring Exxon to reduce emissions is not only do they own a large piece of Exxon, but also every other public company. And climate change is expected to have a large negative impact on global GDP, including large projected hits on stock market loss. So in the interest of time, I'm going to skip most of the math. But part of what I did in this paper was try to answer pushback from the corporate community that it couldn't possibly be worth it for a BlackRock or a Vanguard to sacrifice fossil profits. That is, so I showed that the mitigated damages to their portfolio outweighs the actual lost fossil profits that they force firms to forgo. So if BlackRock forces two firms within its portfolio, for example, Exxon and Chevron, to reduce future emissions by 40%, leading to a 20% loss in share price, BlackRock would lose about $6 billion to reduce global emissions by a little less than 1%. Next slide. In order to estimate the value of mitigated damages to portfolio holdings, I modified the most commonly used macroeconomic climate model. That's William Nordhaus's DICE model that he won the Nobel Prize for a couple years ago. So there's a number of reasons why I think DICE underestimates the cost of climate change, and I'm happy to talk about that in the Q&A. But for now, let's just say that I think DICE represents a lower bound on the cost of climate damages. And for a 1% decrease in all future industrial emissions, which is the intervention that we're contemplating here at Exxon and Chevron, DICE predicts the net present value of the reduction in global climate damages over a 100-year period to be worth $385 billion. So I amended the model to reflect a private sector discount rate, a much higher rate, and the relative percentage of the economy held by a given asset manager. And I find, for example, that BlackRock should value these emissions reductions at around $8 billion. Because the value of mitigated damages outweighs the loss in share price at Exxon and Chevron, $8 billion gained is more than $6 billion lost. It would be rational for BlackRock to proceed with this hypothetical intervention, internalizing climate change externalities. Next slide. So the example that I just presented looks only at interventions at 2 different firms. But of the total greenhouse gas emissions generated by the world's 224 fossil companies, 30% are public investor owned. And Climate Action 100 Plus itself says that more than 80% of industrial emissions are released by the list of companies that it targets. And these investors are targeting not only fossil fuel suppliers, but also industries with a large demand, like automobile and mining companies. And in this way, they can mitigate the leakage effects that occur from supply side only restrictions, and they can target both supply and demand simultaneously in the economy. Next slide. Okay, so now that I've demonstrated that investors have the incentive to internalize intra-portfolio externalities, I'm going to talk about how they do this. So recently, there's been a great deal of attention on the phenomenon of common ownership, with a growing number of empirical studies suggesting that when firms share the same large shareholders, they compete less with one another, as the shareholders want the industry itself to grow as a whole, and they don't push managers to aggressively compete with one another. So this is the first groundbreaking study of this happened within the airline industry. Of course, institutional investors deny that they promote anti-competitive behavior, and institutional investors insist that they lack the power to influence firm-level product supply and pricing decisions. Next slide. However, this same class of investors are much more willing to trumpet their expectations and influence with regards to emissions reductions. So in public statements, many of these investors admit that they pursue climate goals in the service to their broader portfolio value. And of course, these interventions influence supply and pricing in much the same way as collusive anti-competitive behavior would. So for example, you have UBS here saying that the reason that they are aggressive about climate change is because of a means of addressing large negative externalities that affect their portfolio. Next slide. So how are they able to influence emissions reductions? I group the goals pursued by investors into 3 different categories. The first is concrete emissions reduction targets. The second is suspension of anti-climate regulation lobbying and membership in trade groups that support such lobbying. And the third is disclosure of climate risks. And investors have successfully achieved commitments to these goals from a growing number of companies in recent years. Next slide. They pursue these goals through a variety of mechanisms. Skeptics of the common ownership literature argue that no one has demonstrated how shareholder intention is translated into firm-level operational decisions. So I show in my paper how climate activist shareholders have been able to achieve these firm-level results, some of which have been identified in the common ownership literature and some of which are sort of unique to this climate context. So board elections. Investors have voted against the reappointment of directors and pledged to increase these no votes if climate progress is not made. Compensation incentives. Increasingly, executive pay is being tied to metrics other than share price, such as meeting emissions targets. Direct communications with management. Investors report hundreds of meetings behind closed doors and claim that they find these secret discussions far more effective than public engagements. Fourth, broadcasting of intent, including op-eds in the financial press. And 5, votes on shareholder proposals. Not only is support for the climate agenda growing, but increasingly these proposals are actually withdrawn prior to a vote even commencing because boards acquiesce to shareholder demands rather than stage a public battle. Next slide. So This portfolio maximizing objective has some serious implications for how we think about institutional investor behavior, and in fact, a lot of the corporate governance theory supporting shareholder primacy itself. So in the corporate governance landscape, shareholders are given special rights above all of the other stakeholders, like employees, customers, and even bondholders, in determining the direction of the corporation. And one dominant explanation for why this is because shareholders homogeneously desire the maximization of share price, and so have the best interests of the firm at heart. But in this example, a CEO of an oil company, for example, might face a dilemma between maximizing his firm's profits, and doing what his largest and most broadly diversified investors are asking for. And this tension within the concept of shareholder primacy, that maximizing share price and doing what shareholders want may not always be the same thing, has been underexplored in the literature. And my argument has further implications for how we think of investment managers' affirmative fiduciary duties. So I want to make clear that I'm not advocating for a universal duty for asset managers to internalize externalities and minimize systemic risks. Mutual funds and index funds manage investments on behalf of underlying individual, often retail, investors. And these investors don't necessarily share the same diversification strategy and asset allocation as the fund family as a whole. So while internalizing climate externalities might be in the best interest of BlackRock's total portfolio value, it's probably not in the best interest of BlackRock's client that has decided to, for example, to invest in an energy ETF, of which Exxon makes up 20% of the value. Other institutional investors, however, don't face this internal conflict of interest. Pension funds, insurance companies, sovereign wealth funds, endowments, and funds like them have a mandate to grow their entire pile of investments and then pay out beneficiaries from this fund, rather than have individual retail investors select which companies they would like to invest in, often in the form of ETFs. Okay, next slide. So this climate change mitigation effect of investor common ownership is welfare enhancing. And there have been increasing calls for large investors to intervene for social welfare. But this power to control and coordinate product supply across industries implies the power to negatively affect social welfare as well, to transfer wealth away from workers and away from consumers with anti-competitive behavior. And this climate example demonstrates a power to self-regulate that should perhaps give us pause. To paraphrase Justice Douglas, we may not want this power to centrally mandate prices in the economy to be in the hands of a mere handful of investors. One possible suggestion about what to do about this dilemma is to focus on prohibiting the socially undesirable behavior that is welfare minimizing by using antitrust law to police anti-competitive behavior and anti-competitive collusion, while explicitly enabling the social welfare maximizing choices like diminution of systemic risks and negative externalities. This suggests that certain proposals, such as those suggested by Eric Posner at UChicago, to simply break up all the funds into smaller pieces might be too blunt of an intervention. And I think with that, I will conclude, and I really look forward to hearing from the following panelists and opening up our discussion about what they think about my argument. Thank you so much.
Madison, thank you for that great presentation. I want to remind everyone to send in your questions. Do not wait till the last minute. Please send them in. And with that, we're going to hand it over to Fred.
Thanks. Thanks to LPAR and Vanderbilt, Linda, and Madison especially. It's just like it's a great paper, and I hope everybody just enjoyed that last 15 minutes, because I certainly did. I think Madison and I are in violent agreement on many points, and what I wanted to do was to go through and emphasize what I thought were a few important places where we can do further research, some of it empirical, some of it theoretical, places maybe for activism and public policy change. I also, while I agree with sort of all the thinking, I'm maybe less sanguine about what investors are actually doing today. And so I want to talk a little bit about whether Larry Fink is really, trying to improve climate outcomes. And the other thing I just want to say, for this audience is, in some ways this seems removed, right? I mean, you want to attack the problem. Let's reduce carbon emissions. Let's save our forests. Let's do all the things that need to be done. But just kind of going back to the Nettle Meadows, I think we've got to create change in the system because we're just playing whack-a-mole if we keep trying to tweak measurements and goals without changing the incentives that drive the whole system and the feedback loops that drive the whole system. Right now, we really have the wrong set of loops. So with that, we can go to the first slide. The first area I think that would be really critical to get a better handle on is what I'm calling the BRT gap. The Business Roundtable has said, we're announcing companies are now going to run kind of like Madison was talking about. We're going to think about all our stakeholders and how we affect our workers and the environment and human rights. But I think that there's a gap because when they say that, they sort of go on to say in a way that maximizes shareholder value. So they're just sort of talking about what people call ESG integration, places where the companies can be more efficient and both, for example, emit less carbon, but also make more money. And so and that's great. Win-win. Why wouldn't we're all for that? But I would argue that we're really not going to get there because market failure is a real thing. It's not something that economists just made up. So there's lots and lots of opportunities for companies to continue to do better by doing bad, not just doing well by doing good, and through externalizing costs. And I think it would really help to advance the type of thing that Madison is talking about if we just had some hard numbers that said, here's the difference. And I work for an organization that's a shareholder advocacy organization, and we went to companies this year with shareholder proposals and said, we read your CSR report, sounds great. Can you do a study on the difference between what you're doing today and what you could do if you were not forced to operate within a profit maximizing constraint? If instead of optimizing for profits, you are optimizing for staying within planetary boundaries. And I think, there have been huge amounts of work done, obviously, to put numbers on the cost of climate change, the cost of growing antimicrobial resistance, the cost of inequality. Citi just did a report last year that said the US economy will take a $5 trillion hit from racial disparity over the next 5 years. And I think you could really make some progress by saying, well, we can fix, 1/3 of that with win-win solutions, but let's look at what's being left on the table as companies continue to focus on win-win. And I will just say, like, when I read sort of the Larry Fink letter, the letter from State Street and other big asset managers, I still feel as if they are confining themselves to matters where they feel it's win-win. I think Madison didn't talk about it in her talk, but in her paper, she does say some of that she thinks is just almost protective language where they're saying this is win-win, even though wink, wink, they know some companies will lose. But I think just by articulating this win-win, you hold yourself back. So I think that's one big area. You can go to the next slide. The other thing that Madison raised in her paper and in her talk, she quoted Justice Douglas, is this fear of, gee, are we, be careful what you wish for? Should we really be asking the ownership class to make all these decisions? Wouldn't it be better? Shouldn't we just have companies sort of, do everything they can to maximize value, because that's kind of does the work of Adam Smith and the invisible hand, and then have a democratic government come in and regulate that, and that would be the best balance because they can think about all the externalities with a public policy mindset, and let the companies do the work of within those rules maximizing value. my response to that is just kind of, how's that working for you? You know, for a lot of reasons we could talk about, you know, that system, and you know, people sort of talk about Milton Friedman as, you know, the problem and maximizing value and shareholder value, but he fully admitted and said that there were externalities, and he cited pollution as one of those. So people recognize that as a framework. I think that the problem is that framework, private industry maximizing value, government reining them in, doesn't recognize that there's interaction between the two. And when you set industry free to maximize returns, one of the investments they can make, one of the most effective investments they can make, is to rein in government regulation. And that might be through regulatory arbitrage, you know, going to tax havens, going to jurisdictions that don't regulate, you know, workers' rights and in the environment. You can also just corrupt the government with, you know, directly or indirectly through political spending and astroturfing and those sorts of things. And there's also sort of this bare compliance, where you comply, get a lot of lawyers to help you comply, but really violate the spirit of the law. So all of those things enable industry to overcome government regulation. And I think, although you might be worried about concentration of power in shareholders, I would argue it's a step up from concentration of power in corporate managers. And the reason I would argue it's a step up, and again, I think this is something I'm asserting, but a lot of research could be done on, is managers of corporations are concentrated at the corporation. You know, Jamie Dimon says, you know, in his letter a couple of days ago, that, you know, JP Morgan is saving the world and they're doing all these great things. But he also earned $31 million in 2020, almost all of which was paid in JP Morgan stock. So he is incentivized to do one thing, which is increase the value of JP Morgan stock. And I'd rather have index funds making these decisions than Jamie Dimon. And so I think, you know, when you think about who the real beneficiaries are of big piles of equities, maybe it is a good place to center power. And this leads to the next slide. Again, I think an area that we need to think harder about is, who is it that owns the assets? Because we talk about BlackRock and State Street as if they owned assets and as if they benefited from those assets doing well. Now, they do indirectly, because the bigger the pile of money they're managing, the better. But the real way BlackRock makes money is by earning fees. And a lot of the people who decide where those fees come from are the individual companies who decide where to park their 401k plans. And so they have, I think, if you think of them as the stockholder, there's definitely a mixed motive. But the point is, it's not really their money. They're managing money, you know, maybe for, you know, got CalPERS on the call. Maybe they're managing money for an asset owner who's got a bunch of beneficiaries. But even they're not the real owners. The real owners are the beneficiaries, the retirees. And so if we find a way to make sure that the people who control those assets are acting for the beneficiaries, you know, there's a whole set of interests to think about that aren't just, you know, this modern portfolio interest in the single company. We get to, you know, what Madison was talking about, their interest in a portfolio. And even if they own an energy ETF, hopefully their portfolio is diversified. And so we can get to that. But, you know, the fact is that for many of these people who benefit from these large pools of money, whether it's a pension fund or a sovereign wealth fund or an endowment for an educational institution, are just kind of regular people whose main financial interest is actually a job. And so they may care more about the job environment, and they certainly might care more about the physical environment itself. So they have these other interests even beyond their portfolio and even beyond their personal interests. They have community interests. And, you know, the example I always give is, if you went to a retirement investor and said, you might make a little less money, but we wouldn't have had Deepwater Horizon, and we wouldn't have had the Rana Plaza factory burn down and kill more than 1,000 people, in order to, save a few pennies for apparel manufacturers, almost all of them would say, of course I'll take that trade. And so I think it is important to remember what the beneficiaries want. And there's this argument, and Madison rightly raised it, that, well, how do you balance all those different interests? And what I want to say here is, if you choose, this is from a famous Canadian band, if you choose not to decide, you still have made a choice, right? If you just say, well, that's too hard, I'm not going to think about it, then you've decided to go ahead and let people externalize costs and everything that flows from that. So I don't think it's a question that can be avoided. And the next slide. And so, the last point I'll make, because I know I'm running out of time, is just that what this to me all drives to, and I think this question also gets raised in the paper, is, well, but if you start letting companies make decisions that, balance climate and human rights and profits, how does capitalism still work? And I think the way to do that is to say what we're talking about, which is at the diversified shareholder level, you can set some limits that are good for portfolios overall, and go ahead and let shareholder primacy reign within those limits. So it's kind of I call it systems first shareholder primacy, where you let, and I think this is what Madison was suggesting at the end of her talk, you take into account your shareholders' desires for you not to make money by externalizing costs and exploiting vulnerable communities and common resources, but within those limits expressed by the shareholders, go away and compete. And I think that's a workable system that we can approach. It gets to Madison's final comment about common ownership, but I'll talk about that at another date so as not to overstay my welcome.
Brett, thank you. And thank you all for staying on time. Those were really stoking comments. I am going to hand it over to Natasha now, who I believe has the honor of being the only non-lawyer on the entire program today. We are excited to have someone from a different discipline, a star from a different discipline, talking with us. So over to you.
Thank you so much. Good morning. I was thinking just that as I was listening to Madison and Frederick. I'm like, my talk's going to be a little different. I just want to thank everyone for attending, everyone that organized this. Congratulate Madison on her paper, which I just thought was really top notch, and I enjoyed reading it immensely. I thought I would speak this morning from a practitioner's perspective to bring you through the logic that led my company to engage on this issue, both as owners in big oil stocks and also as universal owners. And I thought that might be a helpful way to kind of lead into the discussion and add some color to everything that you've been talking about thus far. So my name is Natasha Lamb. I'm a co-founder and managing partner at Arjuna Capital. We're an investment advisory firm focused on sustainable investment management. I have been considering the dynamics of universal ownership since 2007. When I contributed to a paper that my colleague Adam Sychek authored, which was entitled Climate Change from the Investor's Perspective. We then in 2013 co-founded Arjuna Capital together with another partner. And since that time, we've been actively engaging oil majors on climate change through shareholder activism. And I thought I would first give you just a sense of our investment lens. We consider 3 actions regarding companies, whether to divest, to invest, and or to engage and press for better management of environmental, social, and governance risks and opportunities. I will note that as of this time, as a firm, we've made the financial decision to divest of fossil fuel holdings, although we maintain some positions for our clients that allow us to engage as investors who are concerned about the systemic risks to the economy and our portfolios that are posed by global climate change. So you can go to the next slide. So when you think about climate change risk, it's important to understand the direct risk of holding fossil fuel companies over which you have complete control. You can buy, you can sell, you've got complete control. but it's arguably more important to think about how the actions of those companies will exacerbate climate change, lead to systemic risk, and how that impacts the profitability of many more companies throughout your portfolio, which is what Madison is talking about throughout her paper. You can attempt to hedge some of that risk by investing in clean energy and solution-oriented companies, but that will not solve this systemic risk issue. Next slide, please. So in 2013, we became aware, there was a study that came out from Carbon Tracker of the nearly 3,000 gigatons of fossil fuel reserves globally, and of that, we could only burn 500 more before inciting catastrophic climate change. So that was a threat not only to our diversified investment portfolios, the diversified investment portfolios of the large institutional investors of which you are speaking, but also of the owners of those companies. And because of that, it's led to a lot of people to divest of fossil fuels and sort of step back. And at the time, 350.org issued a global call to divest of fossil fuels. Next slide. And here's just some of the examples of endowments and pension funds that have divested, including the Norwegian Sovereign Wealth Fund, which is the largest pool of assets in the world. For the last 6 years, I've been the board chair of the Intentional Endowments Network. It really came out of that drive to, that sort of push to divest, particularly from students, but then to talk, to create a network of institutions and endowments talking about how can we invest more sustainably because of these systemic risks. And a lot of folks had been making the moral case to divest, but there's certainly a financial case to be made. And as investors within this ecosystem, that is the case that we pursued as we began our engagement. So if you go to the next slide, I throw Jim Cramer up here because he's such a clown, but when Jim Cramer is saying I'm done with fossil fuel stocks, the writing is on the wall. So I think it's important to just acknowledge some of the headwinds that we're facing the sector from divestment, from cost increasing and profit margin shrinking because of structural issues within the industry, because it's just so much more expensive to pull every marginal barrel of oil. You have to dig deeper and process more. And then demand headwinds from future carbon regulation and the competitive threat of renewable energy, which you point out in your paper as well. Next slide. So this is the piece that the Financial Times editorial board, which is considered like the stockholders' Bible, came out with around the time that we were pressing the oil majors on a certain issue surrounding this. And what they proclaimed here is that a growth path is not possible for the fossil fuel companies because they're facing these headwinds, and that shrinking the companies profitably is the only way forward. So I think what one perhaps contention I would make, or critique I would make, or perspective I would bring to the table is to say, I don't necessarily agree that just unfettered, sort of moving forward without taking climate change into account is to the benefit of these fossil fuel companies. I actually think it is to their detriment. Next slide. So I throw this up. It could have been a longer graph, and it would have shown even greater divergence between the S&P 500 and Exxon and Chevron stock. This is since we started engaging in 2013, moving into 14. The S&P is up 127%. You have Exxon and Chevron down 13 and 40% there. And so, the dynamics that we had been warning about for all of these years have very much been playing out in different ways, but certainly huge headwinds being faced. Next slide. This is, again, I'm just going to throw Larry Fink up there because nobody can avoid putting up a picture of Larry Fink. But I just want to say, this story is not just a bit about the fate of one or two companies like Exxon and Chevron. There's a larger discussion on how these companies' actions impact a broad diversified portfolio, like Fink is managing at all of those that he's managing at BlackRock. And here you have him questioning the core assumptions of modern finance when it comes to climate risk. Next slide. So this is sort of where we kicked it off when we started in this engagement. We in 2013 and going into 14, we successfully pressed ExxonMobil to write their first report on carbon asset risk. That is the risk that its carbon assets would be economically stranded in a future where we prevent catastrophic climate change, and the risk it would have to that to their business specifically. Now, if you go to the next slide. Since that time, we have engaged Exxon and Chevron on this issue, and I'll take just a moment to walk you through that logic, because there has been evolution in our thinking, despite the fact that going back to 2007, we were thinking about universal ownership, then thinking about the specific risks to the fossil fuel companies if they get caught flat-footed by climate risk. What we learned in that 2014 report by ExxonMobil, and what all investors learned through that exercise in transparency, is that the company was in fact not preparing for a future where regulation would prevent a greater than 2 degrees rise in temperatures. And that information in and of itself was exceptionally important, because it certainly shifted where we were as investors and how we continued to engage with the company moving forward. In 2015 and 16, and this speaks to that Financial Times article that I shared from the editorial board, we actually asked the companies to start returning more capital through dividends and share buybacks to their investors instead of investing in their highest cost, highest carbon projects. And that was really an attempt to have an intentional sort of shrinking and step down in activity that would allow the investors to maintain their value, to take the money that's coming back, reinvest it in parts of the economy that are, viably growing into the future, and then continue to have a profitable, holding in those companies, albeit smaller. And the problem with those proposals is we couldn't get any institutional investors to vote for them, except for perhaps the Norwegians. And that in and of itself, I believe, is an issue within the system. But we could sort of critique that and go on about that for a while. In 2017, and you might recall in 2017, there was a vote at Exxon that got a 62% vote, a majority vote at Exxon, asking basically for better carbon asset risk reporting, a two degree scenario reporting. We co-filed that proposal. It was led by a bunch of institutional investors that got a huge vote. At the same time, we also put forward a proposal asking the companies, both Exxon and Chevron, to plan for transition. What is your business model when you're facing these headwinds? In 2019 and 20, realizing that we were going to get very limited disclosure on these issues, just enough to prevent, to allow the SEC to say, your proposal's already been substantially implemented by the reports that are out, even though you're not seeing, perhaps a path forward or a real transition plan. We said, okay, we need to look at this from a governance perspective. Started asking for a climate board committee. And have that be staffed by outside consultants, et cetera. And then going into this year, we filed proposals asking for the companies to become public benefit corporations, which goes very much to the heart of what Fred Alexander has been working on in his work, and we collaborated with him on that. And so, there has been an evolution in our thinking over time and motivations. I think in the beginning, thinking both about systemic risk, but also about, our clients that held these companies and the risks to our clients directly, the risks to the companies directly, how they could act in their own enlightened self-interest. But at the end of the day, we have now divested substantially of fossil fuels, albeit, a few clients. And this is really about systemic risk. And that's why we continue to engage as universal investors. And those are the legal risks, the physical risks, the transition risks that you talk about, that you can't diversify away. Next slide, and I'm almost up on my time here. I had the distinction of being the first witness in the Attorney General's case against ExxonMobil, saying that they had misled investors, both in the report that we got them to write and subsequent meetings with ESG investors post that report and during that time. So in addition to being bullied for 7 hours in deposition and having 2.5 hours on the stand, which was a whole bunch of fun, one of the things that the judge asked me was, why don't you just buy Apple? And, you know, the answer to that question goes exactly to your point, Madison. We're not just buying Apple because these are systemic risks. We're looking at this through a universal owner lens. I don't think that's a very well understood position at this point, but I think, you know, your paper and the work that's being done is starting to amplify that perspective. And then my last slide, can't believe I'm in right under the wire here. 1 minute to go, one slide. This is just an example of the proposal that is going to a vote this spring at Chevron, asking Chevron to become a public benefit company. And I just highlight, you know, and you can sort of look at some of the arguments that we're making here, but I highlight a quote from that 2007 paper, which was then picked up by the UN later on, from, you know, my business partner, Adam Sychek, who he himself owns Exxon or Chevron too, because of these universal owner risks. And he is the proponent of this particular proposal. And so I highlight what he says here: a portfolio investor benefiting from a company externalizing costs might experience a reduction in overall returns due to these externalities adversely affecting other investments in the portfolio and hence overall market return. For a diversified investor, there is no place to hide from these costs. They come back into the portfolio as taxes, insurance premiums, inflated input prices, and the physical costs of disasters. So I'll end on that. I'm, you know, again, just congratulations on the paper. I really think it advances this conversation in a way that it needs to be advanced. And thank you for including me.
Natasha, thank you for those really interesting comments. Let me just remind everyone to send in your questions because we will leave some time for questions. I also think that my mistake has snowballed in that Mr. Alexander is a Rick, not a Fred. And I wanted to correct that because I think you are going to become Fred for the rest of the day. So my apologies, Rick.
I'm so sorry, and I know him as Frederick, and I called him Fred because you did. I was like,
I know, I'm owning it. I'm
messing up those.
I've been called much worse.
So our next speaker is James Andrus, and James unfortunately is only going to be able to be on audio. However, I still consider this a victory to have only one technical problem almost to the completion of the second panel. So James, over to you.
Hi, thank you very much. I think Madison's article underscores that market observers need more input from asset owners and asset managers to improve their understanding of incentives and motivations driving coordinated corporate governance action. So I really appreciate LPAR and Vanderbilt for including us in this discussion. CalPERS is the largest defined benefit public pension fund in the United States with about $450 billion in global assets under management. It's significant to highlight the difference between CalPERS as a share owner, actually owning the assets, and BlackRock, Vanguard, and State Street as asset managers. In 2020, CalPERS completed a task force on climate-related financial disclosure report titled CalPERS Investment Strategy on Climate Change. Within that report, we highlighted a number of partnerships in which we participate in, not the least of which is Climate Action 100+. The origins of Climate Action 100+ lie in CalPERS' commitment to mapping its carbon footprint. In 2014, CalPERS became the first U.S. signatory to the Principles for Responsible Investment Montreal Pledge, thereby agreeing to measure and publicly disclose the carbon footprint of our global equity investment portfolio. After analyzing more than 10,000 companies within our portfolio, we found approximately 80 companies were responsible for over 50% of the portfolio's Scope 1 and Scope 2 greenhouse gas emissions. The emissions trajectory of these systemically important carbon emitters is critical in determining whether the global economy will meet the goal of the Paris Agreement to keep global warming to 1.5 degrees Celsius. CalPERS recognized that other global investors were likely to have similar holdings in their portfolios, so we convened a series of meetings hosted by the French mission to the United Nations. The result was a new partnership among regional and global investor networks, North America, Europe, Australia, and Asia, to launch Climate Action 100+. The list of companies in Climate Action 100+ cover a wide range of sectors, including oil and gas, utilities, transportation, metals and mining, construction materials, industrials, chemicals, food and beverage, and forestry. Climate Action 100+ was officially launched at the One Planet Summit in December 2018. This history is intensely important because it gets directly to two things. One, we think that the paper was exceptional in highlighting Climate Action 100+. To our knowledge, it's the most significant representation of this significant work, and we appreciate and applaud it substantially. However, the second part of the paper we find more problematic, and that is the comparison between the work of Climate Action 100+ to the overall debate regarding whether or not asset managers impact product pricing. And we'll get directly to that, but it's important to highlight the history of Climate Action 100+ to highlight the fact that BlackRock, Vanguard, and State Street were in fact not participants. However, they were in fact the major targets in the initial work regarding joint ownership. 4 years ago, we reviewed common ownership research and concluded that such research did not support the conjecture that common owners controlled the pricing of products or services. As stated, the article does a great job of focusing on internalizing carbon emission externalities because of their impact on the broader portfolio, and highlighting that universal owners are appropriately interested in the larger social issues, given that they invest in the entire market. However, as I highlighted for you the history of Climate Action 100+, I hope it's clear that the people creating this history were not thinking about internalizing carbon emission externalities because of their impact of the broader market. They were in fact thinking of the success of the individual companies in which they engage and the long-term prospects of those very companies. As universal owners and as indexers, we purchase the entire market, which means we will hold the stock, and the divestment is an option, but it's a long-term option, not an immediate option. Therefore, we're interested in those specific names and in their success over a longer term. And that's more so the purpose of Climate Action 100+. The article highlights extensively the success of Climate Action 100+, which we appreciate. It is the world's largest investment engagement initiative that engages with the world's largest greenhouse gas emitters. To argue that the coordinated efforts to produce those successes are similar to coordinating efforts to control product pricing is both unfortunate and inaccurate. First off, the Climate Action 100+ is engaged primarily by corporate governance professionals, and it's in a separate side of the investment house, so to speak, whereas the arguments that were made for product pricing initiatives took place by analysts, which are in a separate house using separate processes. Though a great after-the-fact explanation with regard to internalizing externalities, Ms. Condon does not discuss any of the institutional investors' actual motivations for reducing carbon emissions, as I stated earlier, which were more consistent with actually making the companies in which we invest in better. In some, it's like instead of having an oil and gas company or a fossil fuel company, it's the thought that over the long term, those companies can in fact become energy companies that would include large stakes in renewable energy, are cleaning up the processes in which they normally work. With regard to the debate on product pricing, I think it's important that to note that we looked at the issue substantially in 2017. And when I say it's a debate, it was an exceptional debate with many people on either side, so to speak. But we were actually moved by those who basically said that there was not a whole lot to the thought that there was an impact on product pricing. For example, Rock and Rubenfeld convincingly refute the foundations of the original Einar Elage's work by showing that common owners do not commonly own the same percentage of each company. So when we're talking about BlackRock, Vanguard, and State Street, although they owned each company in an airline industry, they owned it at different percentages. So it's unreasonable to assume that somehow they could come up with a mathematical formula that would benefit all companies equally, given that the percentage ownership was substantially different. Therefore, shifting incentives for corporate profits in favor of a weighted average of holdings in an industry does not reasonably hold. Rock and Rubenfeld also undermine arguments that common owners have the incentive and ability to control product price. For example, from a corporate governance perspective, you have things like you engage with the companies, you vote on proxies, you vote on the board, and none of those elements include anything with regard to product pricing. You cannot have a shareholder proposal focus on the actual operations of the company or the product pricing of a company. So unlike in the area in which Climate Action 100 Plus exists, so that doesn't work. According to their work, that's Rock and Rubenfeld, there's no evidence that shareholders vote on competitive strategy and no evidence that directors run on a platform that is directed toward a competitive strategy. So where we are left with is an article in which we applaud deeply. And I've used repeatedly in a number of spaces in which I've talked about corporate governance work and the work of Climate Action 100 Plus and the work of universal owners, especially using the quote provided by Nell Minow on the universal owners. However, based upon the information we know, we fully reject the product pricing comparison in light of the articles that were available in 2017 and 2018 that basically debunked the existence of the product pricing at all, and then more so pointing out that there's a huge difference between the work of Climate Action 100 Plus. So those are our thoughts. Thank you much.
Thank you so much. Sorry we didn't have your video, but it was great to have your audio. We are running a little bit of time, but I want to save time for questions. We have some great questions. But Madison, I want to give you just like at least a couple of minutes to respond to what you've heard. If you wouldn't mind trying to limit it to just a few minutes, that would be great. But I want to hear what you thought about what you heard.
Sure. Thank you so much. Thank you so much for all putting so much time and effort into this. And it's really fun to hear so many people who are really in the weeds of this stuff that I've been thinking about for so long. So I think Natasha raised a thing that I have been like breaking my brain over, which is like, is the corporate governance structure we have set up like totally capable of helping a company shrink in a way that it needs to shrink? And I think that sort of is the question about these oil majors. And I thought that Arjuna's, I cite them in the paper, these requests to actually do share buybacks and dividend payouts, meaning you have all this capital. And I think there's a tension between what Natasha was pointing out and what James was saying, was that actually the intention is to turn oil and gas companies into energy companies. And I think it's an open question of like whether you think that's possible. Like, I sort of think that actually they just need to go away, and that if they were going to pivot to, one, if they were going to pivot to solar and wind, maybe they would have done it already. And two, like, they're just kind of different. Like energy companies as an umbrella is like too broad of a category, and like the infrastructure and the type of training and the distribution, all the different, the business model of the oil companies, I don't think quickly, easily pivots to being an energy company. And in that sense, you have to figure out, like, what do you do as an investor if actually the correct thing, even from a idiosyncratic, not a portfolio perspective, is for the market cap to go down. I don't think that corporate governance theory like totally has grappled with that in a very good way. What was I going to say? I think Rick made a very good point about, there's a feedback loop between, well, why can't we just regulate it? I mean, yes, I would say we just need top-down regulation. Like, why involve all these institutional investors? Let's just regulate carbon. But obviously, the size of these institutional investors associated with the size of these companies has meant that our ability to regulate them has been thwarted by the lobbying process and by like the amount of money in politics. And so I do think that that tie is really important to understand the whole problem about like why we haven't been able to make more progress on regulating emissions. And okay, James's point. So I don't really see how you can get the universal owner without the common owner. Like, I just don't see how those two things are separable. I do think that the portfolio perspective and the minimizing systemic risk perspective has to do with like considering how firms impact one another, what their inter-firm costs are. And that's sort of the exact same thing as what the common ownership people are saying. Climate Action 100+, if you go on their website, they actually have like a very detailed analysis about if companies have made capital allocation that is consistent with their claimed net zero goals. And, they rate them in little different colors about if they're doing like a good or bad job with their capital allocation to be on track with net zero. Many of them are doing very badly. That is obviously about product supply and pricing. If you're telling investors to not invest in a certain oil field or to invest in something that's more low carbon, even if you're doing it like a pretty macro level and you're communicating it through like color-coded metrics on a website, you're still affecting their product supply. You're still telling them to produce less oil and gas, which is what you're telling them, which is necessarily affecting product supply. And that's sort of all I'm saying, is that these inter-firm costs are the same thing in the universal owner and the common owner context. And I don't think that we have like thought through that from a legal perspective about what that means for shareholder primacy and for fiduciary duties. So I took more than a few minutes, sorry.
No, that was great. Rapid fire response. So first question is going to be from Carly Malone, our third year Vanderbilt Law student.
Great, thank you all so much. That was wonderful. This question is primarily directed to Professor Condon, but others please feel free to jump in as well. So your article primarily focuses on defining a new theoretical framework for understanding institutional investor environmental activism. And I'm wondering how you think that translates into an environmental impact, particularly given the discussion in your paper of the kind of ambiguous net welfare effects.
Do you mean how much is the theory like being applied on the ground? Is that what you mean? Is part of your question like how much are these net zero goals real? Is that part of your question?
The question is kind of what the kind of implication of this paper for environmental impacts can be. Does this translate in some meaningful way, or is it more just to be a descriptive matter? And how you think about kind of the ambiguous net welfare effect.
I mean, I think that climate is the most readily available. When you're talking about environmental impacts, they could be many. There's increasingly a focus on biodiversity and putting a number on, the cost to capital growth from biodiversity loss. But climate's so easy to do. It's still hard because of the ways that climate works. Is like the inputs can come from anywhere, they mix in the atmosphere, and the outcomes are distributed. And so no matter who in the world you get to reduce their emissions, it still affects the global emissions total. Versus if you're trying to interact with companies with various footprints in like different parts of the world, it becomes like a much harder monitoring question about like, what is this, what is PepsiCo, who contracts with palm oil suppliers in Indonesia, like what is their impact on like frogs in Indonesia? That to me is a harder question actually, about getting the metrics correct and like studying the environmental impact. But it's still working in the same direction. I just think climate is like way far ahead for many, many reasons.
And I think Mike's going to use his co-host prerogative to throw in a question before we turn to the audience question.
Congrats, Madison, on getting
Thank
selected.
you.
And thanks to the panel. This has been a terrific discussion. I am going to use my prerogative. We've got a growing list of questions. Many of them are really interesting, but just really quickly, I'm wondering whether we might think about the universal owner approach and maybe Rick Alexander's shareholder guardrails on some level as simply correcting a market defect. I wonder whether what's going on at Exxon and Chevron and other companies is actually irrational behavior by the top managers. That, in other words, that what's going on is that ideology or identity or worldview won't actually allow them to get over the motivated reasoning and confirmation bias that prevents people from accepting new facts that are inconsistent with their worldview. And so what's really going on here is that there are incentives that are being developed through these forms of ownership that are forcing the market into a level of rationality that it would have been at had we not had these quirks in management. Sort of what Natasha is doing, forcing the managers to account for something that 95% of all the climate scientists think is going to be real, but the companies aren't really configured to deal with very well. And that could be a question to Madison or to anyone on the panel, really.
I think the bias is for sure real. I mean, I have a new paper in which I wrote the like 6 different reasons why I think climate risk is still being like ignored and mispriced, and biases is one. But one is also just a lag. Like I think I pointed this out in the paper, like in the oil and gas industry, not only do we tie executive incentives to share price, but we also tie them to different metrics, like actual like reserves added in a given year over reserves drilled. And like, we're just incentivizing them wrong. And I really think that requires work like Natasha is doing of like digging into specific metrics about what exactly is guiding a CEO as he makes various decisions during the year. Probably has a lot to do with how he's paid. And like, is he paid about like with a metric that actually measures adding new oil reserves? And if yes, then maybe investors need to work on fine tuning those remuneration metrics, as I think Natasha has made progress. Yeah, Natasha, please.
I'll just add, I mean, I think you're right. I think that part of it is incentives, and we've seen shareholder work on incentives and trying to get those to align more in a more rational way in terms of what's physically possible on our planet. I do think that it's cultural, and just like in the beginning of the panel, that idea that they could become energy companies, right? I mean, back in 2014, we were saying, we want you to be an energy company. Like that was the line. And I became increasingly disillusioned that that was not possible, because yes, we've seen it from the big European oil majors who have been so much more willing to engage with investors in a very constructive, collaborative way, very different than the dynamic, I believe, here in the United States. And every time we would go to a meeting with Exxon, for instance, they'd have their ESG meeting every December. It would be, this is our bioalgae. We're not going to do any renewable energy infrastructure projects because we don't know how to do that. We only know how to move liquid fuels. Now, the European majors are diversifying into more utility-like projects, but there is an unwillingness. And then when you would ask, well, what's the timeline for that? When are you going to do that? There's no timeline. There's no signpost. And so I think there's a lot of cultural issues. And even if you go to the annual meetings, anytime climate change is mentioned, the audience boos. So it's pretty intense.
I really, and I think this comes out, this is the heart of Madison's papers. I don't think that we can just think about changing incentives at the company level. I mean, I think, this goes back to Thomas Schelling and the ecology of micromotives. It's just, you cannot, if you want to maximize the value of the system, you can't do it by asking each piece within the system to maximize its value. It doesn't, that's the fallacy of composition. You've got to think systemically. And I think it is the universal owners who have the ability to do that. And I kind of want to push back on something Jane said, which is the reason for Climate Action 100 is to improve only company by company, because I think that the reality is some companies can, drill and hope that everybody else fixes the climate problem. It's the prisoner's dilemma. And I think at some point you have to face this difficult, sort of uncomfortable fact that some companies have to not maximize value in order for a diversified shareholder to maximize its value. And there's nothing wrong with that. It's just a fact of life.
James, do you want to jump in? All right, Mike, I'll let you.
We may have
lost him.
I'm still here. Can you hear me?
Oh, good. Yes, please keep going.
Okay. I attended the 2016 Exxon meeting in which Rex Tillerson put it another way, in that there is a fact in which energy usage is increasing, and it's increasing at a very substantial rate as countries around the world modernize. And so he felt at that time that Exxon's mission was to meet the energy needs on a global basis. And there are just so many ways you can do that. And so there is a lot of work to do. And I agree with what Frederick is saying, but I think it's intensely complex. We are dealing with our existing infrastructure that is not right for the future, but we're stuck with it for a very long period of time, like 30 or 40 years. So there's a huge problem to solve, and the expectation is that we might be able to get at it with innovation, but we do need the people who know most about energy to actually be a part of the discussion and to stop pushing back on it.
I just want to add one more thing, because at that meeting, he also said, well, temperatures could go up 4 degrees, temperatures could go up 6 degrees, and we'll just adapt as a company, as though there was no role being played by the company. And I think that is a very frightening model. And using the straw man of the world's poor, to which you are providing energy, when we all know that leapfrogging to renewable energy would be much better for the world's poor, who are the most at risk from physical disasters and climate change and weather change. I just think, that narrative is a very dangerous one.
And that's certainly a narrative that we see playing out in the political process. I'm going to throw another little bomb into the conversation, if I may. And if people have interest in the idea of the worldview or ideology or culture of managers and boards, I'd be happy to entertain the offline emails and so forth. I really want to study that, and we're starting to do some of that. But, we're just starting to see now a fascinating move where many of us thought that the move toward private governance might help depolarize the political process. So if we bring out the role of the private sector, we might have moderates and conservatives on board. In the last 2 months, we're beginning to see the flip of that, which is that some politicians are trying to essentially polarize the marketplace and go after the big companies, things that are climate related or voting rights related. And so I think an interesting question is, what are the implications of the whole universal owner theory for whether or not politicians might be able to leverage it into a more polarized marketplace rather than a less polarized policy development system, which I find to be a little frightening, but I'm curious about what you have thought to that.
Yeah, a very strange, the Trump administration was just, can you guys hear me?
Yes.
Okay, great. Okay. So yeah, at the tail end of the Trump administration, we saw lots of funny things happening for people who, I study the stock market and stock market theory, and generally people who I would consider to be more conservative or on the right believe in private ordering and less interference by regulators and just letting the private sector duke it out. And sort of the opposite was happening at the end of the Trump administration, where both the Department of Labor and the OCC all intervened to try to stop financial institutions from making their own private decisions about scaling back on lending to oil and gas companies. That was in the banking case. Or the Trump administration often would side with they entertained this argument that the asset managers like Larry Fink cared about ESG for like their own personal political reasons rather than fulfilling their fiduciary duties to their client underlying investors. And that became a very political question about whether Larry Fink was just being a Democratic Party donor and was like wasting all of the funds of the Main Street investors. And so the Republican Party had this, to swoop in and protect the little guy against Larry Fink, which is just a very strange telling of the story. But it's this weird political allegiance I see happening where there's increasingly more of a conflict between, I would say, like the manager CEO class and the asset manager class. And to me, that was part of what was going on in the Business Roundtable story, where they were sort of like, we're not about shareholders anymore. Now we're about stakeholders. And I think it's in part because shareholders have been actually like very aggressive and like more pro CSR and pushing companies to be more green in ways, I think, as Mike alluded to, like their ideological ways and the ways they were trained in business school to behave is different. And the shareholders are moving quickly and more fast. And that's becoming a really political issue.
So unfortunately, we are basically out of time, but we had several questions from the audience related to plastics. And so I want to just super quick hit that. Lots of variations on the question, but an example would be, do transition plans involve expanding markets for single-use plastics? And how are we better off if the transition is back towards traditionally irresponsible corporate behavior? Natasha, do you want to try a quick response at that? We literally have a minute.
I mean, what I would say is that, we have heard that, well, we're moving to the chemicals business as though completely ignoring this giant global, plastic dump in the middle of our oceans. So I think, one of the things that needs to be taken into consideration by these companies as they're transitioning their businesses is we don't want to be replacing one problem with another. Because the same social license to operate issue that you're facing right now and are going to face more and more into the future, you're also going to face on the waste side. And so I think that's part of we always talk about kind of getting beyond regulation, right? Like you're really caught flat-footed if you're not preparing for what is so clearly coming down the pipe. And sort of making that shift, in my opinion, just seems not that we don't need, any plastic as a globe, but I think there's some naivete in that.
Thank you. And I wish we had more time for this. And I'm going to remind everyone that the slides will be posted after the conference on the ELI LPAR website. Thank you all for a wonderful discussion. We are going to transition now to the next panel. And I'll just remind everyone and apologize that you will be able to hear our audio as we are testing the tech for the next panel. So thank you all. It was a really fascinating conversation.
Yeah, that was a terrific.
Hi, everybody.
Thank you all.
Thank you so much. Great to see you all. Appreciate the conversation.
All right, welcome back to our next panel. Thank you again for being with us today. We had a great conversation on our last panel that I think we will continue on this one. I do want to mention that unfortunately Elizabeth Pierre is not able to join us today. She had an unavoidable conflict. She sends her regrets and we miss her. And with that, I'm going to hand it over to our third year Vanderbilt law student, Meredith Barrow, to introduce our panel.
Hi, my name is Meredith Barrow, and I'm a third year law student and articles editor for LPAR. I apologize, my video is not working, so I will be doing this just through audio. This panel is dedicated to discussing Charles Lee's article, Another Game Changer in the Making, Lessons from States Advancing Environmental Justice Through Mapping and Cumulative Impact Strategies. Charles Lee currently serves as a senior policy advisor for environmental justice at the U.S. Environmental Protection Agency. He led the development and implementation of EPA's agency-wide environmental justice strategic plans and has served in multiple capacities, ranging from creating the United Church of Christ Environmental Justice Program to directing EPA's Environmental Justice Office. He was a charter member of the NEJAC, where he chaired its Waste and Facility Siting Committee and served on the National Academy of Science and Institute of Medicine Committee on Environmental Justice, as well as numerous other panels. In these capacities, he led efforts to incorporate environmental justice into EPA's rulemaking process develop models for collaborative problem solving, transform brownfields redevelopment into a community revitalization paradigm, advance approaches to address cumulative risks and impacts, lay a strong science foundation for integrating environmental justice into decision-making and advancing environmental justice at the state level. I'd also like to welcome the two commenters joining our panel today, Carol Monahan Cummings and Benjamin F. Wilson. Carol Monahan Cummings was appointed Chief Counsel at the Office of Environmental Health Hazard Assessment in October 2003 and was reappointed by Governor Brown in December 2012. Prior to this, Ms. Cummings served as an Assistant General Counsel for the California Environmental Protection Agency and as a prosecutor with Sacramento County, where she prosecuted criminal and civil environmental enforcement cases, including illegal hazardous waste transportation, storage and disposal cases, and water and air pollution cases. Ms. Cummings received her law degree from Empire College School of Law in Santa Rosa, California, where she graduated magna cum laude in 1995. Benjamin F. Wilson is the chairman of Beveridge and Diamond, a top-ranked law firm focused on environmental and natural resource law and litigation. He represents major corporations, developers, and municipalities in complex litigation matters involving Clean Water Act enforcement, wetlands development, Superfund, and environmental justice matters. He served as the Deputy Monitor for Emissions and Environmental in the Volkswagen AG emissions proceedings and served as the court-appointed monitor for the Duke Energy coal ash spill remediation project. Mr. Wilson graduated from Dartmouth College and from Harvard Law School. I'm thrilled to welcome Mr. Charles Lee and our two panelists today. And so with that, I'll hand it over to Mr. Lee to hear more about his article.
Thank you. Next slide, great. Thank you very much, Meredith. And I want to first of all thank the Environmental Law and Policy Annual Review, the Environmental Law Institute, the Environmental Law Reporter, and Vanderbilt Law School for including me in this program and selecting my article. I have to say a word of thanks to all the people that worked with me on the article, but also the people who did the work and made the writing of the work of the article possible. And of course, especially Meredith for her work in editing the article and for the LPAR journal and pulling this panel together. There are 2 points I want to make, overarching point to provide some context. And the first is that over the past 10 years, there's been really a very tremendous developments in environmental justice, particularly at the state level. As we will see through this presentation, they've had some huge impacts, but also taken in a larger context. These are not just advances in terms of environmental justice, they are actually advances in terms of environmental law overall. The second is that the article really is a work in progress. And it is about an issue that's very dynamic and fast moving and growing and deepening and maturing. And so we will see the article talk about a set of issues at a point in time, and there are a lot of things that have happened since then that builds on that. And so with that, let me get to the first slide. And of course, this article talks about state experience in terms of environmental justice mapping and cumulative impacts. And I just want to ground this this presentation in terms of two of the more important environmental justice screening tools that kind of lay the foundation for the kind of trajectory of the path of development that we're going to be talking about. The first is, of course, California's CalEnviro-Screen, EJ screening tool, and US EPA's EJ Screen. Not to go into a lot of detail about this, but they are both, ones that look at environmental factors and population characteristics or demographic factors. The specific factors that are included in CalEnviro screening and EJ screening on the slide. The one thing that you will notice is that in for CalEnviro screening, there is a methodology to develop a single cumulative score in terms of ranking environmental impacts. The one thing I will want to make sure to emphasize is that both of these are in fact cumulative impacts tools. They have at their core a cumulative impact methodology, which is the combination of pollution burden and pollution or pollution burden and population characteristics or demographic indicators. Next slide. So the article, talks about 5 lessons learned. The first 3 on this page are the ones that I'm going to focus upon in terms of how cumulative impact is a core strategy for advancing EJ, how there's been a lot of experience, progress, and results in terms of facilitating resource investments, and then how there's some emerging models that we should be looking at. However, there are 2 other ones that I guess for this presentation are more in the background, and they have, but just as important, and they have to do with the process involved. And so one are, of course, a set of guiding principles for how one will go about developing really authentic EJ mapping tools. And the other one is the fact that when we look at progress in environmental justice, not only at the state level, has always involved a combined effort from communities, academia, and government. So next slide. So stepping back a little bit, and I said this was a work in progress. We can now look at the EJ mapping in terms of a historical arc, and like I said, it starts with CalEnviro screening, EJ screening, and then there's a set of laws that were passed. In California, the Senate Bill 535, Illinois' Future Energy Job Act, and New York State's Climate Leadership and Community Protection Act that have really focused upon the directing of resources to benefit disadvantaged, overburdened, marginalized communities. And they have, in fact, now become the predecessors to a major initiative under President Biden's Executive Order 14008, and that is the Justice 40 Initiative. And along with that, the development of a climate and economic justice screening tool. These all have directed, a significant amount of resources to areas of EJ concern. And in this case, in the EO 14008's case, 40% of a set of climate-related resources are meant to be directed towards disadvantaged, overburdened, and marginalized communities. Next slide. So dissecting that a little bit, this is what has happened in California. And when I say, we're talking about resources for communities of EJ concern being resources of scale, we're talking about significant scales now. And I can go back to the point of time, not in the too far distant past, when we used to say like a $25,000 environmental justice small grant was really a big deal. And that it in fact was. But now we're not talking about just that. We're talking about resources that really are needed to make differences, make significant impacts in these communities. And in California, SB 535 directed 25% of funds from the Greenhouse Gas Reduction Fund to benefiting disadvantaged communities. And how do you determine that? Through CalEnviro screening. And between then and 2019, as it was discussed in the article, some $12 billion have been, come from the Greenhouse Gas Reduction Fund, at least 25% of which are more than $3 billion have gone into benefiting EJ communities. So we are now talking about resources of scale, and in fact, we need to be talking about resources at this kind of level in terms of investments in what are previously disinvested communities. Next slide. And the other thing to note is that through the existence, because you have the existence of a CalEnviroScreen methodology, it has become influential in the passage of other kind of legislations, as well as influence the implementation of many pieces of legislation, not the least of which are things like the human right to water in California, SB 1000, which is consideration of environmental justice in the general plans, cumulative risk in permitting, and the Community Air Protection Program. Next slide. So in the other states, Illinois passed a Future Energy Jobs Act, which stipulated that 25% of those resources from a program called Solar for All go into EJ communities. And so that includes at least $750 million, which is designated for low-income programs in terms of solar workforce, and energy efficiency. And they use a methodology that includes elements of CalEnviroScreen and EJ-Screen. And I would discuss that at a later slide. In New York State, which mandated 40% of the program resources in renewable energy go into disadvantaged, overburdened communities. And they're in the process of designing the program in terms of program definitions, design, and criteria. Next slide. So we're also seeing this kind of proliferation and maturation of these second generation EJ mapping tools that take into account cumulative impacts in terms of the combinations of social and environmental factors. And these are, some examples here of these taking place both at the state and municipal levels. And I think there's something like 12 here, but last time someone told me there are at least 19 that now exist, and I'm pretty sure that this number is going to be growing. And next slide. And if you start to look at the ways, some patterns in which these are developing, just like in Illinois, you can see a methodology or a paradigm that's beginning to emerge. And that has to do with the fact that there is a use of CalEnviroScreen's methodology for a cumulative impact score, data elements from EJ-Screen. And the importance of EJ-Screen is that it is it covers the entire nation, and it has data accessible to everyone. It's on a web-based platform, highly interactive, and therefore, can have profound impact because of the ability of people to access and use it. And then of course, the additional factors in terms of of available data, or the data around issues that are of concern or interest to for communities in that state, based upon state or local data. Next slide. So I just want to kind of start to conclude by talking about another kind of development based upon mapping. And this is kind of a interesting, kind of more focused, but very important use of EJ mapping. And that has to do with looking at phenomena like, past structural systemic racism, inequities like redlining and other things that are just receiving a lot of attention. So this slide has maps from redlining maps from a project called the Mapping Inequality Project, which makes available shapefiles for redlining maps from the 1930s for about 200 cities. And this is overlaid over the CalEnviro screen results for the city of Oakland, California, and you can see the relationship, between the areas that are the red line areas, meaning the hazardous areas, those are depicted in the red boundaries with the results of CalEnviro screen. Again, the red going from red to green, the red being the most having the most environmental disparities. There's a lot to be unpacked in terms of this particular slide, but I just want to point this out because this points to, like I was saying, this is an evolving process, a maturing process, a deepening process, and this is just a tremendously important new area of research and scholarship. So I'll go to the next slide, which I will conclude by posing some questions that is based upon this, and for future, with implications for perhaps future development. And so one is, of course, there's so much activity now. So what are ways that we can best share information, do education, cross-fertilization, so that we have the best use of available data resources and lessons learned and best practices. We also know, and this is what the second question speaks to, the fact that, all this, there's a great amount of interdependence as well as innovation with respect to the development and use of EJ data and platforms. So what are the strategies that can best maximize the alignment in terms of data and these technologies and methodologies, the efficiencies and effectiveness in terms of their use? And this is related to the third question, which has to do with, we know that environmental justice, to address environmental justice, there are multiple types of applications and functions, approaches, and they have all different types of analytic requirements. So how can you start to think about platforms that can actually accommodate that in terms of a fit for purpose type of approach? And then lastly, of course, and I wanted to make sure that we're continuing to think about this, is how can mapping be used to elucidate kind of systemic racism, other structural inequities, and their relationship with current environmental conditions. So with that, I will stop.
Charles, thank you. Those are great questions. And boy, I mean, I have to say some of those maps were pretty powerful.
Yeah, I'd like to adapt some of those maps from my property law class. Some of those are remarkably powerful.
I'm just going to remind everyone to send in their questions, and I'm going to hand it over to Carol.
Sorry. Hi, I'm Carol Monahan Cummings. As was mentioned, I work for the Environmental Protection Agency in the Office of Environmental Health Hazard Assessment. Our office is primarily comprised of scientists, toxicologists, medical professionals, and we do research and not bench science, but research and development of scientific opinions and tools for other people to use primarily. We have no enforcement authority, so we are a support, we provide a support function for the rest of the agency and some other agencies within California. Next slide. So Dr. Lee covered the kind of the development of the EnviroScreen program and the tool itself pretty well, so I didn't want to repeat that, but I did want to highlight that we just released our fourth major update to CalEnviroScreen, and we are currently inviting comments on that. We're doing a number of workshops throughout the state, and doing things that trying to make sure that we get community input and also input from academics and others on the changes and what other things we may need to take into account as we go forward. Next slide. So I think Dr. Lee already kind of addressed this, but our in California, we started this process, the environmental justice program itself in the early 2000s. When I was first hired with Cal EPA, I worked in the office of the secretary, and about half of my time was spent on the environmental justice program. And so I provided counsel for the community organizations and advisory groups that worked with us to develop the definition of what environmental justice is and adverse impacts and those kinds of things. So I was more directly involved then. What we have now is the environmental justice program within, we call our office OEHA because it's too long for us to say. But within our office, it has kind of been transferred over to our scientists because they developed this tool. And so it's not so much a legal issue anymore. Of course, I have some oversight on it, but it's really that team of scientists that has developed this, and we have some really excellent people that are working on this project, and they're also very open to assisting other jurisdictions in trying to develop something similar or using the our past experience so that you don't have to run into the same kinds of issues in developing your own program. So I would encourage anybody that has specific questions about their jurisdiction, how they could use it, to contact the program, and we can help more in kind of a one-on-one process to work through the issues for you. Next slide. So when we developed the first version of CalEnviroScreen, we developed these different major areas that we wanted to measure. So we have exposure, sensitive populations, the effects of environmental pollution and other conditions, and then we included socioeconomic factors. I think the most contentious piece was the socioeconomic factors, because some people felt that we should only look at the pollution burden and not look at the kind of demographics of the people that were being affected, but we felt it was important to look at both of those. Next slide. So as Dr. Lee mentioned, these are the different measures that we include within CalEnviroScreen. The newest version, 4.0, includes information on children's risk of lead exposures from older housing. And that was information that wasn't available at the time we developed it. As we go along, the fact that we have this tool has really encouraged different groups, including community groups, to develop information and data that we can incorporate into the tool. So we expect that as we go along, and as we have already, we add information to the tool, as well as sometimes we take indicators out because they don't really add much value to the ultimate score, or we think that something else would work better for those, and so we do change it over time. Next slide. So what the overall result of including all this information is that we can basically map in a spatial way the types of exposures that are occurring in California, and also we can overlay that with the social economic factors in those same areas at the census tract level, and we can develop these scores for different areas to show combined, it's a combined score for both pollution and the existing conditions for the population in that area. Next slide. So as you can see, there's lots of different layers for within the model for CalEnviro screen. These can be kind of pulled out. So for example, if somebody just wanted to look at the sensitive populations, you could just use the 3 layers that are related to that. You can look at environmental effects, or you can split out and just look at hazardous waste sites, for example. And all of these can be shown in a map format. So it's it's a visual, and it's also kind of a way to look at how widespread the issue is in a given area. Next slide. So one of the new things that we did with 4.0 is we didn't add a race or an ethnicity component to the tool itself, but we did develop information about the race and ethnicity of people within these different areas that have already been identified as highly impacted. You should keep in mind, which you can see on the chart on the right-hand side, that California does not really have a dominant ethnicity or race at the moment. We have Hispanics are just slightly a majority currently, but we don't have the information from the most recent census. But you can see from the chart on the left that the 10% least impacted neighborhoods in California are right around 67% white. Okay, and then on the right side there, you can see that 90% of the people in the most impacted areas are people of color. So clearly, this reinforces the outcome on the tool itself. It shows that there are demographic issues that, it's kind of a chicken or egg. You can't say necessarily that the reason these effects are seen in those areas is because of the number of people that are there that are of color, but I mean, it's fairly obvious that there's a big difference. And so we're still looking at ways that we could address that in California. It's a little bit more difficult in some ways because we have a constitutional limitation on how we can take into account race or ethnicity in government contracting, education, and the third area is escaping me. But essentially what the voters did is eliminate affirmative action within California many years ago. And recently, in the most recent election, there was a ballot initiative to try and repeal that prohibition, and it didn't pass. And so we have to be mindful of that when we take actions that would cross over in those areas of education or contracting or employment in California. So that's one of the reasons we don't directly include race or ethnicity in the tool or in the score that we use. Next slide. So this is a very busy slide, but what we wanted to do is show that this tool it has been used in a whole variety of ways. And as Dr. Lee mentioned, these uses are kind of evolving over time. And we do expect that the tool will be used more and more for a variety of purposes. But what I found interesting as I watched the program develop over the last 20 years or so is when we initially were looking at disadvantaged communities or trying to define which communities might be overburdened by pollution or other environmental issues within their neighborhoods, there was a lot of resistance to what people called redlining and identifying communities that people, that businesses shouldn't, be in, or it was a negative to look at those kinds of things. Once we started to develop laws that required money to be invested in those communities, like through the greenhouse gas program, then that resistance shifted, and we actually now have communities that are arguing that they are disadvantaged in some ways because there will be investments in those neighborhoods or those areas. And we actually more recently have been required to not just invest 25% of the funds to benefit the communities, but there needs to be 25% of the funds that is actually used in those areas. So you can't do a project outside a particular community. Well, you can, but you still have to do some that are within the community. So I think that's a positive there too. And anytime that you are proposing to directly fund improvements in a particular area, then you do shift the conversation, and people aren't nearly as resistant to being kind of identified as disadvantaged, and also businesses are not as resistant to coming to those areas or developing their businesses in a way that can improve the conditions in the neighborhoods rather than just stay away from them because it's going to be an issue for them. I think that the growing area to look at, and we're not really clear how it's going to work, is in permitting and siting of new facilities or existing facilities in the disadvantaged areas. The issue for us is that we're state government, we're looking at the whole state. When you make permitting decisions or siting decisions, that's really a local decision. And so it kind of requires buy-in from those jurisdictions to use some of the information we have to make those decisions, or it requires the state to pass laws or executive orders or whatever is necessary to either require or encourage the local jurisdictions to take these issues into account. So that is all I wanted to say right now, so I pass it back.
Thanks. Thank you, Carol. It really is very, very powerful, again, when you look at the data. All right, next is Ben Wilson, and omitted from his bio in the introduction was his most important affiliation, which is he is the Environmental Law Institute board chair, or wonderful board chair. So Ben, over to you.
Well, thank you, Linda, for that very generous introduction. And I would first like to thank the Environmental Law and Policy Annual Review Conference for allowing me to be a part of this very special program and to be with Charles Lee and Carol Monahan Cummings. I'd like to thank the Environmental Law Institute, the Vanderbilt Law School. My family lived in Nashville for a number of years. We lived in Nashville and later in Hermitage, which is right next door, those of you from Middle Tennessee. And so it's a real thrill to be with this group today. I've known Charles Lee for 30 years. Quite frankly, he's in a most unique position to assess the developments within the environmental justice movement by virtue of his nearly 40 years addressing environmental justice issues. He's advanced them. He didn't simply address them. His work establishing the link between low-income and minority populations goes back to his work as the principal author of the seminal report, Toxic Waste and Race in the United States, in 1987. It was the first national study to examine the relationship between the geography and demographics of hazardous waste sites. This study was one of the first studies to provide data supporting what had long been suspected by many and what Carol and Charles just detailed, a pattern of disproportionate environmental burdens in low-income and minority areas. So when Charles Lee says EJ mapping will be the next game changer in the environmental justice movement, we listen. So environmental justice is inherently a conversation about geography. Where in our states, where in our cities or counties or towns are environmental burdens most concentrated? Maps represent a natural tool for articulating and addressing environmental justice issues. In many ways, using mapping as a way to identify cumulative impacts is the natural outgrowth of what Charles and his colleagues started in 1987 with that seminal report. And I'd like to talk just a little bit about the future of EJ mapping. Might we advance the slide, please? In fact, let's go one further. There we go. And Charles distills 5 key lessons, if you will, in my view, from Cal in EnviroScreen and from EPA's EJ Screen. I seldom recommend reading off a slide, but in this instance, we'll make an exception. Addressing cumulative impacts is a core strategy for advancing EJ. This is clearly embedded in EJ mapping tools. Those of you who have been involved with EJ communities know that it is the straw that breaks the camel's back, that 3rd, the 5th, the 8th, the 10th locally unwanted land use disproportionately placed in that area, which is so frustrating. Guiding principles for successfully developing an EJ mapping tool can and have been articulated. EJ mapping tools can help facilitate resource investment in underserved communities. Charles writes about that. Carol is living that, and I appreciate your last illustration there. Existing and emerging EJ mapping tools also promote a replicable model for other jurisdictions. And obviously progress in EJ has come from a number of efforts of communities, academia, and government. These are extremely important lessons. Charles does something else, though, that most of us, or at least I don't do very well. He promotes a next generation of environmental justice thinkers and leaders. And not buried, but featured prominently are the names of others who will play significant roles going forward. His conclusion that EJ mapping tools can serve as this replicable model is supported by the growing number of these maps we're seeing around the country. I don't know if it was Charles or Carol, but some say 12, some say as many as 19. But the fact of the matter is they are coming online. They are being used in conjunction with other information. They are being improved. If I could go to the next slide, please. There we go, nice and busy. And I apologize for the difficulty perhaps in reading it. But California EnviroScreen, the Office of Environmental Health Hazard Assessment, on behalf of Cal EPA, recently released a draft Cal EnviroScreen 4.0 for public review. It includes data on 21 indicators of pollution, environmental quality, and socioeconomic and public health conditions to calculate a score for each of the state's 8,000 census tracts based on their overall pollution burdens and vulnerabilities. It expands the types of facilities considered and the types of issues considered. I thought Carol did a great job pointing out the information as it relates to lead paint, and extremely important. At the same time, President Biden's January 27th executive order on tackling the climate crisis at home and abroad requires the White House Council on Environmental Quality to create a climate and environmental justice tool by July, which could mean updates to EJ Screen. I have every confidence that our CEQ designee, Brenda Mallory, and her team will do just that. Senator Edward Markey and Congresswoman Cori Bush recently introduced the Environmental Justice Mapping and Data Collection Act of 2021, which would establish an interagency committee to develop detailed mapping down to the neighborhood of specific environmental risk factors. That's a very powerful tool. Next slide, please. And someone is smiling because I'm near the end. The future of EJ mapping lies in its potential expansion across new jurisdictions and how these tools will be used. As it relates to the public sector, it gives us a chance to distribute benefits to underserved communities, jobs, infrastructure, enhance enforcement efforts by connecting maps to tools for investments, like legislation, like regulations, like policy. We're already seeing this. And again, Carol showed us several excellent illustrations in her presentation. As Charles mentions in his article, California's Greenhouse Gas Reduction Fund dedicates 25% of proceeds from a fund established by the Global Warming Solutions Act of 2006 to disadvantaged communities. I like Carol's point, and the money needs to be spent directly in those communities. EPA designated Cal EnviroScreen as the method to identify disadvantaged communities for these investments. A second point, EPA has recently announced that it will pursue a more integrated approach for EJ Screen, using it in rulemakings and policy decisions. So we're already starting to see this happen. And the pronouncements made by the Biden administration about taking a unified approach to environmental justice, the idea that this is not simply the job of the Environmental Protection Agency, but it's a job in which the White House intends to participate directly. It's the job of the Departments of Energy, Agriculture, of HHS. So this is a much different approach. This is not your father's Oldsmobile. This is a new environmental justice approach. And as has already been noted, we could see EJ Screen come into play to identify communities for President Biden's Justice 40 initiative. And that requires that 40% of benefits from federal investments in certain areas, clean water, infrastructure, remediation of legacy pollution, clean energy, et cetera, will go to disadvantaged communities. And the president just announced last week his $2.25 trillion investment. There's one thing though, Charles, that I would like to add, and you and I have had this conversation. I believe that EJ Screen and our California tool and the tools of all the other states also offer something for the private sector. You see, I spend a good deal of my time representing private companies, representing municipalities. They too can use these mapping tools. They can do a better job of avoiding or mitigating adverse impact of their proposed projects on EJ community. But I would advise everyone, and I advise my clients, do not stop with a map. You have to ground truth the area, and you learn something. You have to speak to the people who live and work in those communities. All the history is not on a map. All the history cannot be captured by one tool. And the feeling and the direct impact of people is absolutely essential. And Charles, you did us a great service, and I hope you must know that, almost 35 years ago with that initial study. But what you're doing with this article, which you described as an ongoing work, not a finished product, is that I think you are furthering dialogue among people, among activists, among academics, among environmentalists, and I dare say among industry as well. And we need new solutions for a new time. I think it was another president who talked about disenthralling ourselves and the dogmas of the quiet past being inadequate to the stormy present. This is a stormy present, but there are solutions. And these mapping tools that you have highlighted, Charles, that Carol has eloquently described, give us an opportunity to do just that. Thank you. Thank you, Charles, for what you've done.
Thank you, Ben, and really interesting points. I had not even thought about it as a private governance tool as well. Charles, would you like to take a minute and just respond to any of the comments that you heard?
Well, yeah, no. Well, first of all, thank you, Ben, for all those kind words, and thank you, Carol, for kind of going into the the ins and outs of the complexities of CalEnviroScreen. I mean, none of this stuff is easy, and certainly we've learned a lot, but but it's always been through a lot of hard work and experimentation and mistakes and so on and so forth that we come to this point. So I would just like to say, the kind of questions that both of you are posing, particularly Ben, what does this mean for the private sector? And things of this nature are really important for all of us to consider. And I do think that Ben's point about the importance of mapping, I would just go as far as to say there wouldn't be an EJ movement without the ability to put everything on a map, because that's what happened, back in 1987. And I remember back in 1987, there was no GIS, so we drew those maps by hand. And now, this is becoming so much more powerful, and the data that informs it becomes so much more ample. But what this does, and that's why I showed the map of redlining and environmental conditions. This really brings this home to people to better understand, to engage with each other, to organize, and and there's a story behind those maps in which communities are taking these and using them to effectuate change in terms of public policy change. Like taking these climate impacts and addressing them in Richmond, Virginia's general plan, or ballot measure in the state of California, or things like that. So, this is really an evolving story. I don't think that, one can say, you can write something and then, it doesn't change, but it is really remarkable. You can write something in 2019 and in 2020, or you can publish something in 2020 and 2021, the whole situation is all different, and this is very, I do think that this speaks to the fact that, environmental justice is becoming more and more of a powerful lens by which to understand, the current problems, and Ben put it right, what we're talking about in terms of environmental justice is the spatial organization of environmental benefits and burdens. And what better way to understand that than through tools like EJ mapping. So, so I guess those are some initial comments, and we could talk about this forever.
Well, we do have a whole half hour, so that is great. Our first question is going to come from our Vanderbilt law student, Meredith Barrow, who is on audio. Meredith, do you want to jump in with your first question?
Yeah, so I'd like to address this first question to Mr. Lee, but any of the panelists also, I'd love to jump in if you have opinions on it too. But given that some states probably will be more receptive to utilizing EJ mapping tools than others, and probably certain communities and municipalities also, what are some obstacles you foresee in implementing this technology in those more resistant areas, and how could those be overcome?
Well, I think first of all, you know, when we're talking about states and municipalities, everyone is different. You have to treat them all as different. You know, there's no way that. But I think that you know, there are a growing number of states, an ever-growing number of states, which are you know, responding to issues of environmental disparity or disproportionate impacts, and you know, disparity overall in society. That you know, there's a real pressure from the bottom up to address these kind of issues, and that is just a real impetus. So what happened in California? And everybody says California is, you know, California and everybody else is different. Well, I don't think the issue is that different. You know, it's you know, the kind of circumstances in which they play out may be different, but it's the same issues. And you're going to see, I think you're going to see that happening in other parts of the country. You know, I mean, we're seeing, like I said, you know, there are lots of statutes related to environmental justice being passed you know, in states, you know, on a, you know, ongoing basis. So, you know, you have some of those that I talked about. New Jersey passed a law last year around cumulative impacts of permitting. Massachusetts has passed a law around climate and had a huge number of environmental justice provisions in it. So these are all ongoing. So I think that, you know, people are going to see that people are going to learn from that, you know, and there's going to be more and more momentum, and you know, that's going to, I think, a big sway in those states where this is not, you know, they're a little bit, you know, going to approach it a little bit differently. I do want to say, however, you know, I don't think that environmental justice is. I mean, I think environmental justice is an issue that affects people in terms of their everyday lives, you know, and so I think all people, all states, all government eventually have to respond to that.
I'd actually like to follow up on that with a question. I co-chair Mayor Cooper's Sustainability Advisory Committee here in Nashville, and we are really interested in these mapping tools. And I guess I wouldn't mind a little practical advice. I mean, what do you suggest to cities that maybe don't have a deep history working on these issues and don't have as many resources? What does it take to use these tools in terms of resources and staffing? And maybe to Carol, are there certain pitfalls that you guys have already figured out that cities now using them could avoid?
Well, I think what the primary thing that we did and we learned from the beginning of developing the tool is, and even before that with just developing the structure that the tool fits within for environmental justice in California, is that you have to start with community input. You need to have the buy-in from the communities that you are trying to help. And you can't have it a top down, you know, the government's here to help you, and so we're going to tell you what we're going to do for you. It really is, these communities know far more about their own issues than you can find through databases, even though we use a lot of databases. But we've been consistently doing these outreaches and like, for example, on 4.0, it's a draft, and we're taking it to these communities to ask them what they think of it. Does it make sense to them? Somebody mentioned ground truthing. That's really what we're trying to do. Is does this really reflect the situation in your area? So I think you have to have some kind of develop a relationship with communities and encourage them and include them in the whole process from the beginning. And then the other piece, of course, is what I mentioned, that if you can incentivize the process so that the communities want to, in a certain way, be identified as disadvantaged, and that also encourages businesses to invest rather than run. So I think those would be the main things.
Charles, any additional thoughts on sort of how to help cities that want to adopt these tools?
Sure. I think that what Carol talked about was really the hardest part, is how do you make sure that communities are part of the process, that is a really authentic process, and that, that you're really reflecting the concerns and needs of those communities, and then, making them and other stakeholders be part of the process ongoingly. I mean, I think the one reason I was driven to write that article is I began to realize actually the data part of this, the technical part of this is not that hard. You will find, I mean, I didn't mention this, but let's see, in Washington State, in Michigan, in Maryland, and I believe probably many other places, a lot of the technical work for the development of those tools, some of which are adopted by government and some of which are not yet adopted, were done by graduate students. And so this is not something that is now, out of reach, and in fact, a lot of the data is available pretty readily, right? And so, it's a matter of how two things. How do you get communities to be really part of the process, and how do you get government to buy in and decide like Ben said, it's about the uses of these. How do you get government to commit to using this type of information?
Linda, might I
sure.
just jump in briefly? I think Nashville has amazing advantages. You have Vanderbilt, you have Tennessee State University, you have Fisk University, you have Meharry Medical College. You have enormous resources. And so if you can combine academic leaders and students, like the bright young woman I just heard, Meredith, a little earlier, with dedicated faculty, I think you can make enormous progress. Someone, as it relates to the earlier question, what about if I'm in a state where we don't have a state mapping tool like they have in California? Well, I'm really from the deep South, not really from Nashville, but from Jackson, Mississippi. And I remember a time when there was a federal law on civil rights, but state laws that went just the opposite. And so the point is, does the federal government have the will to act on these issues? And are they prepared to do what's necessary? So don't get me wrong, the more tools, the better. But the EJ tool that Charles is talking about, I don't think it's limited just to the states that voted for President Biden or just to the states that voted to President Trump. I think the information is there for everyone to see, and it can be supplemented. So I would submit to you there's this can happen, but there has to be community involvement. The motto of the EJ movement is we speak for ourselves. And that's not so much the lawyer speaking, that's the community speaking, and the lawyer and others executing that strategy.
One follow-up I had, I thought that's an intriguing discussion. I think, by the way, overall, this has been a great panel discussion. Ben, one of the things that occurred to me is that if there are maybe roughly half of the states that are probably pretty resistant on justice issues, that maybe that is the place where the idea you launched before could be pretty intriguing, that we already have a model supply chain contracting effort underway at ELI with Vanderbilt and Wharton and other schools participating. You can imagine a global network of supply chain contracts that include requirements to use a mapping tool like this to include environmental justice issues, and that could be a gap filler in states and other places that aren't doing this.
Well, you're absolutely right. Your concept is similar to what I would describe as private governance, right? There's one thing for EPA to act, it's one thing for this powerful entity to act, and government has at times chosen to do that. So I like your example. Having said that, I do not want to in any way undercut the strength and the importance of the California tool.
Totally agree.
The federal tool and the work of Carol, Charles, and others. It's really remarkable.
Well, not surprisingly, because our audience is primarily lawyers, we have a handful of questions that are a variation on the same theme. And here's one of them. Are these mapping tools frequently used by regulators in making permitting and regulatory decisions, or are they more valuable for deployment of government funds, brownfields grants? And a similar question was, has anyone employed like a veto standard, right? You don't get a permit if the mapping shows X. So would love to hear what people think, what's happening on the ground, how it's being used.
Well, in the main, the uses of the EJ mapping tool has been around deployment of resources, and I think that that's because I guess the kind of analytic requirements to support something like that are probably less stringent, if you will, than say regulatory decisions. So I think there's a spectrum of the kind of uses, and so we're seeing great strides in terms of the use of these EJ mapping tools for something that is actually very, very important, because what are EJ communities but communities have been historically been disinvested in, and so one should not underestimate the importance of that, but then on the other hand, as we move into other functions, I think it remains to be seen exactly what the uses, how these are going to be used. I do think this all takes place in a tapestry of because these tools are becoming more mature and precise. Like Calvin Virus Screen 4.0 is a lot more precise than Calvin Virus 1.0. And I know one of the things that Carol may not have pointed out is the amount of investment that OEHA has made in terms of the development, fine-tuning of the tool, including things like grants to academic institutions, to ground truth information, like, for example, San Diego State University looking at air impacts in the U.S.-Mexico border area and things like that, right? So there's a lot of things so there's more and more of that, as these become more sophisticated and more accurate, is uses may become more possible in terms of other types of informing other types of decisions. But I do think that one of the things that I've learned about environmental justice and how you integrate it in governmental programs is that there are a lot of different types of functions. So when Ben talks about the use, we're not just talking about one use, or it's not like, it's like, what did they say? If you only had a hammer, then everything is a nail, right? But that's not true in reality. There's lots of different types of questions. So I think over time, as we are becoming more mature about environmental justice issues and what they represent in terms of, how do you solve them? And then as we get the data tools, the data and the tools, and how they're used more sophisticated, we'll begin to find the right fit for purpose kind of matches.
Carol, did you want to comment on that as well?
Well, yes. I think I mentioned that going down to the permitting level or siting level is a little more difficult than overall policy kinds of things that a state can do. But for within Cal EPA, we have the Department of Toxic Substances Control, and we have the Air Resources Board and the Water Board and other agencies, and they have used Cal Virus Screen scores and mapping to focus enforcement efforts in areas that have the most impact, so that instead of maybe having some quota, you got to go to each facility every 5 years or something, regardless of whether they've had any violations. They put their resources into these areas where they would have the most impact. And I'm hoping that over time we'll be able to see some kind of changes in the pollution level and things like that. But I think it's so incremental that it's going to take some time. But there was not counting virus screen so much as cumulative impacts and environmental justice was added to the general plan requirements for local jurisdictions some years ago, and some of them are using Cal Enviroscreen to do those kinds of calculations, if you will. So permitting, it's going to be a while before you can see how to directly use this kind of information, but certainly it would support things like saying, we've just got too many, or we've got plenty of this kind of industry in this area. Maybe we should site it somewhere else, or maybe we won't permit it to expand, that sort of thing.
All right, we will move to another question. So this is for Charles, and the question is to your fourth point about systemic racism. It'd be interesting to see if mapping can make apparent inequities across silos like environment and social. Research shows the biggest predictor of housing loss in my community is whether you have health insurance, for example. And those areas of housing loss map directly to environmental risk and ethnicity and income. These mapping tools, oh, that's it. This is the most not user-friendly question box ever. Charles, do you want to take that question?
Yeah, I'm not sure if I heard the whole question, so if you could just repeat it.
Yes, I'm sorry. So this is about your point on systemic racism and whether it would be possible to map inequities across silos, like environment and social. And what this questioner was saying is, look, the biggest predictor of housing loss in my community is whether you have health insurance, for example. And those areas in turn map directly to environmental risk, ethnicity, and income.
Absolutely. And I think, I think, what was that? People say that, the biggest predictor of life expectancy is the zip code in which you live in. And that, of course, is a statement, or that speaks to the cumulative nature of all these different types of stressors, coming together, right? And so the one thing about, this builds off of Ben's point about, the importance of mapping. It's a very, what it does, it puts information and visualizes it in a way that you can think about it in a lot more integrated way, not in silos, but, how these things overlay, each other, and then you can see a fuller picture. And of course, and the interesting thing about this is that, it's not just that you can't, that you just kind of put this together. There are ways to then measure the relationship and the strength of the relationships. Like, for example, building off of the redlining map conversation, right? There was a study that looked at the relationship between redline areas and the location of urban heat islands. And drew a quantitative kind of relationships. But then it also looked underneath that and looked at, what are the kind of things that, drive that, like impervious surfaces or tree cover or things like that. And then if you start to look at, many of the other things that the question speaks to, you can actually begin to see those interrelationships as well, I think. So I think, and there are efforts now that kind of begin to look at these types of interrelationships in terms of health outcomes, in terms of housing outcomes and things of that nature. You should also note that the project that the Mapping Inequality Project is part of also has done maps of other types of phenomenal, like urban renewal or the location of interstate highways and things like that. And so those are all very much interrelated.
If no one else wants to jump in, I'll go to the next question. We have a handful of questions that all go sort of to the same point of what's missing from the mapping tools. So one of them is, I didn't see much in your presentation on water quantity or quality. What should I make of that? And then there are some other questions about similar, like what about biodiversity, for example?
Well, I think, I mean,
sorry.
please, Carol, if you can jump in, that'd be great.
Yeah, I do. I'd have to go back and look at it, but I do believe that we have water quality and related issues in our tool. So we have data on their water sources and things like that. So we had some limitations on that at the beginning because some of that data wasn't publicly available over kind of concerns about intentional contamination or something. So we were able to get that a little more recently and integrate it. But each one of these have their benefits and their limitations, and so as you go forward, sometimes the use of this kind of a tool can push more research or more data gathering, and then you can incorporate it into the tool at a later time. And really, some of it can be done by the communities themselves. So, and I can't remember what the second, the biodiversity. I'm not sure exactly what they're referring to, but I think the point that Dr. Lee made about, heat islands and tree cover and things like that is probably as close as we've been able to get to looking at some of those contributing factors.
I think one of the things that is just, the state of the development is well, most of these mapping tools have a lot of air data because generally speaking, we have more air data and the other areas are not, the data is not as robust or available. So, and that's speaks to, like Carol said, the need to get more research and fill those data gaps. The other is, it's just not biodiversity. I think another big challenge right now is how do you combine data around, say, climate impacts, and pollution impacts, and that I think has a set of challenges in it of itself, but is a very important thing to try to start to do.
If I could just say briefly though, and forgive me, I literally have a hard stop, but there's no tool that's complete, and everyone would tell you there's always new information that comes in every day. And so, but this is a helpful and a useful tool. It's a little bit like radar or a compass. It doesn't necessarily tell you all that you want to know, but it puts in context where you are. And I think used in conjunction with other tools, communities that have are able to use this, but also realize they have citizen suit rights under citizen suit, federal, state, local agencies that will act, enlightened companies that are paying attention to these issues. You're never limited to just one thing, but this is a tool in the toolbox, and I think one that can help people who wish to resolve problems.
I love ending on that very upbeat and optimistic note. So thank you all so much for joining us. Great discussion. And I'll remind everyone as we transition to the next panel, we cannot mute the audio. So unfortunately, you're going to hear us testing once again the tech of the next panel.
Yes, thanks everyone.
Yeah,
that was terrific.
Thank you. That was a great conversation. Take care.
Thank you, Charles.
Bye-bye. Thank you.
Best to everyone.
We're going to go ahead and get started. Welcome or welcome back. This is the last panel of the day. We've had some great discussions so far and very much looking forward to this panel. I am going to hand it over to Haley Rudham to introduce our panelists.
Hi, everyone. My name is Hallie Rudham, and I'm a third-year law student at Vanderbilt Law School and also an articles editor with LPAR. So I'm excited to introduce Professor Joshua Macy, author of Zombie Energy Laws, which was published in the Vanderbilt Law Review. Professor Macy's article also was awarded the 2020 Morrison Prize, which recognizes the most impactful sustainability-related legal academic article published in North America during the previous year. Professor Macy is currently an assistant professor at the University of Chicago Law School. He specializes in energy law, environmental law, bankruptcy, and the regulation of financial institutions. Professor Macy's work has been featured by several prominent news sources and law reviews. Previously, he worked at Morgan Stanley and also clerked for Judge J. Harvey Wilkinson III on the Court of Appeals for the Fourth Circuit. Professor Macy graduated from Yale College, the London School of Economics, and Yale Law School. Additionally, I'd like to introduce the individuals who we are fortunate to have commenting on Professor Macy's article today: Jessica Bell, Margaret Claiborne, Miles Farmer, and Hampton McBeth. Jessica Bell is currently the Deputy Director at NYU School of Law's State Energy and Environmental Impact Center. Previously at the center, she served as the Clean Energy Attorney, where she focused on energy law issues at the Federal Energy Regulatory Commission and on state energy policy matters. Prior to joining the center, Ms. Bell was an associate at the law firm Spiegel and McDermott. Before that, she was an honors fellow in the Office of General Counsel of the U.S. Environmental Protection Agency and also a law clerk for the Honorable Andrew M. Mead of the Maine Supreme Judicial Court. Ms. Bell earned her JD from Columbia University Law School and her undergraduate degree from Wellesley College. Next, we have Margaret Claiborne, who is one of 4 founding partners of Rock Creek Energy Group. She has over 18 years of experience counseling and representing electric industry participants on a wide range of federal energy regulatory and administrative litigation matters. Ms. Claiborne counsels clients in commercial transactions involving FERC jurisdictional assets, and she also represents clients in administrative litigation matters before FERC. Prior to co-founding Rock Creek Energy Group, Ms. Claiborne worked in private practice at the law firms Van Ness Feldman, Davis Wright Tremaine, and Winston & Strawn. She graduated from Washington University and St. Louis School of Law and earned her undergraduate degree from Carleton College. We also have Miles Farmer, who is currently a legal advisor to Commissioner Allison Clements of the Federal Energy Regulatory Commission. Prior to this role, Mr. Farmer focused on energy policy, law, and strategy through private practice, nonprofit, and government service work. Most recently, he worked as an independent consultant for clean energy companies, associations, advocacy organizations, and foundations. Before that, he served as a senior policy advisor on Governor Cuomo's energy team. Mr. Farmer also served as a senior attorney at the Natural Resources Defense Council. His legal career originally began in private practice as an associate at the law firm Latham & Watkins. And after graduating from Yale Law School, he clerked for Judge Deborah Ann Livingston on the U.S. Court of Appeals for the Second Circuit. Mr. Farmer earned his undergraduate degree from Yale University. Finally, we have Hampton McBeth, who works as a staff attorney alongside Ms. Bell at NYU School of Law's State Energy and Environmental Impact Center. Within this role, he has contributed to several State Impact Center reports on the work of state attorneys general in the environmental, clean energy, and climate space, and has edited a book, Looking Back to Move Forward, Resolving Health and Environmental Crises, which was published by ELI Press in 2020. Previously, Mr. McBeth served as a senior legislative assistant for Congressman Adam Schiff and as an Institute Fellow at the Georgetown Climate Center. He also graduated from Georgetown University Law School and Occidental College. We are very grateful to Professor Macy and the commenters for taking the time to speak with us today. And now I'd like to hand things over to Professor Macy to tell us about his article.
Great, thank you,
Hallie, for that really kind introduction. Briefly, I just want to thank Mike, Linda, and Heather for organizing this and bringing me here to ELI. Also to LPAR, it's been really wonderful to work with you. And Hallie, thank you for your terrific edits over the last few months. And just finally, it's really special to be here at Vanderbilt, which published this article, and also where in some ways I think the paper takes a series of arguments that energy law scholars have been making for a decade or so, especially Jim Rossi, who's on the faculty here, and Alex Klass, who's been featured here, and just sort of situates them historically and tries to find a unifying theme. So should we go to the slides? Is that? I think my first slide is sort of dramatic, or I tried to find a good picture. Or the second slide, not, yeah. So the paper makes a very simple point, which is that over the past 100 or so years, we have restructured the electric power industry to introduce competition in all sorts of areas. It used to be that energy markets were not characterized by competition, and that the argument is just that there are some doctrines that developed out of the very peculiar market structure that characterized energy markets, and particularly electricity markets, at the beginning of the industry. And those doctrines sort of continue to distort electricity markets, impede decarbonization efforts, and generate inefficiencies all around, despite the fact that we've abandoned many, if not all, of the economic tenets or precepts that led to those doctrines. So I call these zombie energy laws, but you can also think of them, can we go to the next slide? You can also think of them as sort of the legacy of Sam Insull, who, so in 1898, Samuel Insull, who was Thomas Edison's lieutenant, goes before the National Electric Light Association and delivers this speech in which he says, electricity is best served by a single provider whose rates will be regulated by a utility commission. And he thought he was putting forth an economic argument that the electric power industry was a natural monopoly, that all segments of the industry were best served by a single provider, and where you'd have a utility commission regulate the rates and services that it provided. Whether or not you buy this argument is worth debating, and there's been a 50-year debate about its merits. But beginning in the 1970s, a series of economists argued forcefully that generation, the process of generating electricity such that it could be used, should not be regulated in this way. And this inaugurated a decades-long deregulatory movement in which we tried to subject generation to competitive forces. But the point of the article is that it just tracks these three legal doctrines, something called the filed rate doctrine, the certificate of public convenience and necessity, and the idea that utilities should be entitled to cost recovery. And it argues, and it builds on the work of people like Alex Klass and Jim Rossi, who've long argued that these are not sensible doctrines, but it argues that they can be, it points to the specific things that justified them. So the filed rate doctrine limits judicial interference with rates set by a public utility commission, or more usually by FERC. The idea is that antitrust and sometimes contract claims and tort claims are actually a revision of the rate that was set by the regulator, and those claims should all be mediated before FERC. This has time and again made it difficult to go after people like Enron for market manipulation, and it's been approved on stare decisis grounds. And I'll go into a little bit of more detail in a bit on it. But the second legal doctrine I'm critical of is the certificate of public convenience and necessity. So to build energy infrastructure, and in particular transmission lines, you generally need a certificate of public convenience and necessity. And there are a lot of factors that go into the certification process, but the one that I'm critical of is the requirement that an administrative body find that there's market demand for the infrastructure before authorizing new construction. And finally, and in some ways the most obvious doctrine, is the idea of cost recovery for vertically integrated utilities. We spent 40 years trying to subject electricity generators to market forces, and yet the fact that some utilities continue to be vertically integrated, that some companies own both transmission and generation, can distort the market forces that dispatch the cheapest generators. So if we can go to the next slide, please. So I'll start with the filed rate doctrine, which is usually traced back to a case called Keogh versus Chicago and Northwestern Railway Company. Keogh, I should note, is about a railroad case. It also was not the first filed rate case, but it was a significant one. And the basis of the filed rate doctrine was that electricity, or in this case, railroad companies, had a legal obligation to serve everyone in a franchise or in a service territory at non-discriminatory rates. And a core concern of the court and also of regulators was this idea of cream skimming, that if a railroad provided service to from New York to Albany and from New York to Boston, it might cost the exact same amount of money to build railroad lines to both cities. The costs of the infrastructure are fairly consistent, whereas the costs of providing rail service to an additional person are very, very small. And so the two destinations might have the same costs. And so in order for the railroad company to provide consistent services or same quality and cost services, you would have the Boston line cross-subsidize the Albany line. More people go from New York to Boston than go from New York to Albany. And so if you want to provide them with the same rates, it's based on a sort of system of cross-subsidization. And this was explicitly the rationale of all of the early filed rate cases. Over the next 20 or 30 years, we sort of just started applying it rotely, but it was originally based off of cream skimming. In 1989, the Supreme Court heard a case in which it affirmed the filed rate doctrine on stare decisis grounds. But I think it's just odd, if not somewhat horrifying, that we have decided that electricity markets should be subject to competition, and yet the legal doctrines that make sure that competitive markets are fair do not apply with nearly the same force in electricity markets as they do in all other markets. And that's based on a sort of a reasoning that no longer applies. So if we can go to the next slide, please. And so today, I sort of covered this in the last slide, but today energy markets are plagued by market power. We had utilities that were given exclusive franchises, and we've sort of tried to mitigate those market power issues, but we're still working on that. And yet, if an ordinary antitrust regulator tries to bring suit, utilities often have a defense that the suit should go before FERC and may no longer be ripe and can therefore be dismissed if FERC has done any sort of action. It also can be used arguably can be used in bankruptcy. That's to be determined. And okay, let's go to the next slide. So the second doctrine I'm critical of is the certificate of public convenience and necessity. I am obviously not the first person to criticize this. Anyone who followed the Clean Line fiasco or read the series of books and law review articles about that knows that the certificate of public convenience and necessity can impede the ability of renewables to provide electricity where needed. So Clean Line Energy is just illustrative, but it received a lot of press. But it was a large renewable development, and it faced a series of hurdles because it could not build the transmission infrastructure necessary to connect its renewable assets to urban areas that would use them. Notably, one of the issues Clean Line faced was that the state of Arkansas had a law that stipulated that only utilities would be given a certificate of public convenience and necessity. And the only people who were utilities were people who already owned transmission infrastructure in Arkansas. This is obviously circular because no new entity could ever build transmission line in Arkansas unless they already owned transmission lines. But if you think, as I do, that Arkansas utilities, which own both transmission and generation, are not eager to help their competitors that own generation assets that will compete with them, that they won't want to help their own competitors sell electricity that would compete with Arkansas utilities. This necessary of finding a demand and limitations that protect incumbents make it very, very difficult for low-cost electricity providers to sell electricity where it is needed, and also for renewables, which are often located very far away from urban areas, to sell electricity. And the Certificate of Public Convenience and Necessity, it originally had these 5 justifications, and they're all based off of the public utility concept. There was concern about wasteful duplication, destructive competition, cream skimming, the ability of incumbents to raise capital. And they were all, though, based off this idea that the incumbent, this careful regulatory scheme, had to be protected, which is one that we have explicitly abandoned now that we've shifted towards competition. So let's move to the next slide. It's notable that in the Clean Line Order, people were explicit about this fact. The law governing public utilities was not drafted to comprehend changes in the utility industry such as this one, where a non-utility private enterprise endeavors to fill a void in the transmission of renewable power that is needed. And yet, many state regulators don't have legal authority to support competitors to their own incumbents because they've drafted Certificate of Public Convenience and Necessity laws to be explicitly incumbent protecting. Some states explicitly prohibit, such as Michigan, out-of-state utilities from building transmission. Others do a slightly more circuitous route. Some give incumbents a right of first refusal, but they are all based on this idea that you should have a finding of that there's demand, and that I think no longer makes much sense. I want to make one qualification about my point about the Certificate of Public Convenience and Necessity, which is that you can understand CPCNs as doing 2 things. The first is ensuring that there is demand, and the other is serving a regulatory role, which is that you want to make sure that large infrastructure, which can be highly disruptive, doesn't raise violate environmental laws, that it doesn't violate land use protections. And in my opinion, you should think of those latter category as part of a licensing regime. That and that is not something I'm critical of. That you should not, the finding of demand is what I think is unique to the public utility concept, whereas ordinary legal protections to make sure that companies don't break laws designed to protect the environment and property rights are not part of that public utility concept. And I'm critical of the demand requirement, not the licensing regime. Okay, next slide, if we may. So cost recovery, I mean, this is the definition, sort of idea behind Insel's theory, which is that if you are shielding companies from competitive forces, they will charge monopoly rents. And so to prevent that from happening, you should have a public utility commission strictly regulate the rates and services it provides in order to mitigate those monopoly abuses. Notably, in some markets that have been restructured to subject generators to market forces, utilities that still manage to rate-based transmission have worked to sneak generation costs into the rate base that is supposed to be used to support transmission. One common strategy is fuel pass-through clauses in utility rate-making proceedings, in which coal-fired generator may be allowed to pass the cost of purchasing coal onto its rate base. And if you think that markets should be based on the idea that the lowest cost generators provide electricity in a given moment, then these types of clauses make that difficult. and so I think to the extent that you want markets to figure out which generators are dispatched in a given moment, you should not shield markets from competition. In fact, things like a carbon tax or subsidies for clean energy attributes can be dampened to the extent that some generators are able to use their captive rate payers to recover certain costs. So my solutions obviously follow from my critiques. The filed rate doctrine should be overturned by the Supreme Court to the extent that it has no justification today. I don't think that we should use it. At the very least, we should overturn it in restructured markets. Certificate of public convenience and necessity should not require a finding of demand in order to let a company that wants to participate in a market do so. That doesn't mean you get rid of environmental and land property rights protections. It just means that states should relax the demand requirement, or better still, we should have a national, Congress should pass a law giving FERC authority to do siting for transmission. And finally, I think that states that have encouraged their own utilities to participate in competitive markets should really permit those markets to act as they're designed to. And sort of half steps in which states tell their markets to compete with other generators, but then let certain generators protect themselves from those markets should stop doing that. That creates barriers to entry and exit. That's both inefficient and impedes, makes it harder for renewables to enter the market. So with that, I'll turn it over to the next speaker, and thank you again.
Thank you so much. And I just want to remind everyone to send their questions in. Don't wait, send them as you think of them. And we are going to hand it over to Jessica and Hampton.
Great. Thank you for inviting us to join today. I'm Jessica Bell, Deputy Director of the State Energy and Environmental Impact Center, NYU School of Law, and I'm here with my colleague Hampton McBeth. The State Impact Center works with state attorneys general on environmental, energy, and climate laws and policies. Before we get into the details of our comment on Professor Macy's article, Hampton will provide a brief overview of the perspective from which we approached our comment. Then I'll discuss our reaction to the article, and Hampton will conclude our piece of the presentation by identifying two other zombie energy laws. And of course, I note that our comment, our presentation today do not represent the views of NYU School of Law. Hampton?
Thank you, Jessica. And next slide, please. Given our professional focus, we approached Professor Macy's article with the perspective that states have made a great deal of progress in the clean energy transition. Particularly at this moment of time, with the incoming Biden administration, there is increasing hope that the US will begin to lead on the global response to the climate crisis again. Later this month, the US will announce its nationally determined contribution, or NDC, to the Paris Agreement to reduce greenhouse gas emissions. Critical to this effort will be creating a cleaner, more resilient grid and electrifying the economy. States have made progress on reducing power sector greenhouse gas emissions and have committed to making further reductions. Next slide, please. This graph shows US greenhouse gas emissions by sector of the economy from 1990 to 2019. On the progress front, you'll see states have played a large role in helping the country reduce power sector greenhouse gas emissions by about 4% after 1990 by leading the shift towards clean energy sources. A majority of states have renewable portfolio standards now, which according to one study is responsible for 45% of renewable energy growth in the US since 2000. Particularly during the Trump administration, states have made bold climate commitments. 15 states have now adopted 100% zero carbon or carbon neutral electricity targets. As you can see in this graph, transportation has contributed more greenhouse gas emissions from the power sector since 2017. This highlights the importance of electrifying the economy to the ultimate goal of reducing greenhouse gas emissions. and we need a clean, robust grid to support these efforts. Yet, as Professor Macy points out, zombie energy laws threaten the progress and the commitment states have made in cleaning their power sectors. Jessica will now discuss our reaction to two of these zombies. Next slide, please.
Thanks, Hampton. The first zombie we discuss is cost recovery or retail rate regulation. As Professor Macy notes, rate regulation was developed to protect consumers and mitigate the potential for abusive behavior by utilities acting as natural monopolies. As Professor Macy also notes, the electric system has changed though, and things like open access transmission requirements and deregulation have overall increased competition. But utilities, especially those that are able to recover their costs from captive ratepayers, often with a generous return on their investment, may still need more incentive to behave. Professor Macy talks about coal plant self-scheduling. This allows plants to run even when signals from the competitive wholesale market say that they shouldn't. Plant owners can have an incentive to operate this way because, for example, they may be on the hook for purchasing fuel regardless of whether they run, and in any case, retail ratepayers will generally foot the bill. We also note another egregious example in our comment. Pictured is Duke Energy's Roxborough plant in North Carolina. Coal combustion residuals, also known as coal ash, are produced from burning coal in power plants and may contain pollutants like mercury and arsenic. Duke's mismanagement of its toxic coal ash in North Carolina, for which it tried to get ratepayers to cover penalties, cleanup, and of course a healthy return on its work, is another example of the perils of rate regulation. One of Professor Macy's suggestions in his article to address these issues is for FERC to prohibit generators that benefit from retail rate regulation from participating in the wholesale market. While we agree that FERC has a role to play, we are wary of asking FERC to be in the position of determining which state policies are to be favored. If you have followed FERC's actions on minimum offer price rules or the infamous MOPR, you know that FERC needs no invitation, and it is indeed a slippery slope as FERC categorizes more and more state clean energy policies as market distortions. And as a side note, while we expect that capacity market and other reforms are getting underway and will go in the right direction on MOPR and other issues, we still do not advocate for FERC to have this gatekeeping role over state policies. Rather, advocates can focus efforts on state commissions to reform retail rate regulation, and indeed, we are seeing some examples of successful pushback on utility plans and requests. FERC should encourage the availability of information from wholesale market operators and review market design rules that affect these issues. And I do think we may see moves in these directions with technical conferences that FERC is holding this spring and summer. Next slide, please. Thank you. The next zombie is certificates of public convenience and necessity that are required to build transmission. The transmission build-out that is needed to bring electricity from areas with high renewable potential to population centers often goes through multiple states, requiring certificates in each state and facing opposition in each venue. State laws can create additional hurdles, like the requirement that a developer be a public utility as defined by state law that Professor Macy noted Cleanline encountered in Arkansas. We do think that we need some check on what a developer plans based on profitability and how a developer evaluates market demand, though, particularly as we are still working on getting market forces in line with decarbonization goals. This is clear from looking at the gas pipeline certificate process, which runs a bit differently as it is centralized at FERC currently, and it is very inclined towards granting certificate applications. And there are many problematic aspects of this pipeline process that should not be carried over for transmission projects. Rather, there may be tactics like using existing rights of way or sweetening the deal for local communities affected by a project by highlighting benefits such as job opportunities for overcoming local opposition. But ultimately, we do agree that more federal involvement is needed. There are also ways to advocate within our existing processes and our existing grid, for example, to more efficiently use transmission lines that should be pursued in the meantime as well. Now I will turn it back over to Hampton to discuss some more lurking zombies that Professor Macy's article inspired us to highlight.
Next slide, please. We identified two other zombie energy laws in our comment. First, many states have old laws that promote, subsidize, or require the use of gas, a source of the greenhouse gas methane, to heat buildings, yet they have strong greenhouse gas emissions reduction targets. For example, New York in 2019 adopted the Climate Leadership and Community Protection Act that has a strong greenhouse gas emissions reduction target of 85% below 1990 emissions levels by 2050, leading one commentator to indicate that there is a limited role, if any, for gas in New York in 2050. But the pre-existing New York Public Service Law states that providing gas to residential customers is in the public interest. Restricting residential customers to fuels, including gas, they've used in the past and incumbent utilities that have provided that fuel. As states seek to achieve their climate goals, they will have to identify and address these lurking zombies that are a threat to their climate ambitions. Next slide, please. A second zombie energy law is the ban on economic activities at highway rest stops. As you'll see with the text on this slide, agreements between the US Department of Transportation and state DOTs are required to contain a clause that prohibits states from permitting, quote, automotive service stations or other commercial establishments for serving motor vehicle users to be constructed or located on the rights of ways of the interstate system, end quote. Originally adopted at the beginning of the country's highway building boom in the middle of the last century to protect local businesses from new competition, the ban is now a threat to the development of an electric vehicle charging network needed to electrify and clean the transportation sector, which, as we discussed earlier, is now the largest sectorial source of greenhouse gas emissions. However, we are hopeful that allowing for the building of electric vehicle charging stations at federal rest stops might be included in climate and infrastructure legislation that moves this Congress. Next slide, please. Thank you, and I will now hand it back to you, Linda.
Thank you both very much. A lot of really good information there. We're going to go over to Miles next and encourage everyone to send in their questions.
Well, thank you, Linda, and thanks for the invitation to speak, and to the ELI and LPAR teams for putting together a fantastic conference here. It's a real pleasure for me to be able to provide comments on Josh's paper. It's a great piece and one of many significant contributions he's already made to the field. And it's still a little hard for me to get used to him being a professor, because I first met Josh in the context of us being on the same inner tube water polo team when he was an undergraduate. So it's fun to now be working in energy together. And before getting into substance, I should note that I'm participating in this conference in my individual capacity. My comments here do not represent FERC's views, nor do they represent Commissioner Clements. So Josh identifies these zombie energy law practices, and I would say to some extent takes a slash and burn approach to killing off those zombies, which seems like a reasonable instinct when you're encountering zombies. But I might take a slightly different approach of, rather than torching them, seeking to transform some of the features into something else, because I think at least in a few of these contexts, the existing doctrines, or there are aspects of these broader regulatory approaches that hold continued relevance, and ways in which they might be adjusted to meet current and future energy system needs. And I actually think we saw a bit of that in Josh's remarks just now. So I'll take each of the three areas that he's identified in turn, starting with the certificates of public convenience and necessity, going to rate regulation, and ending with the filed rate doctrine. With CPCNs, as mentioned, the core insight is that an assessment of market demand is anachronistic in the context of regulating competitive merchant transmission development rather than monopoly service, because in that context, there's not the risk that ratepayers will be on the hook for infrastructure that's kind of ultimately unnecessary and we don't need to worry about those kind of utility perils that Josh identified. My first point, though, in response is to just emphasize a necessary caveat here, which is that merchant transmission development is currently the exception and not the rule. And while Order 1000 adopted by FERC provides for competition in certain types of regional planning, that competition is done pursuant to needs identified by these regional transmission planning process rather than identified organically by the market itself. And in the local transmission planning context, monopoly utilities do still continue to plan the system. That said, I think that with regard to transmission that's planned, it's relevant to consider that CPCN proceedings may not be the best way to assess those market needs, because in fact, those planning processes that FERC has do look at market needs, and they're actually kind of more sophisticated ways of addressing that market need question. And I would say that that type of planning is more relevant than ever, and in fact kind of needs to be made more robust and expanded. I think even the staunchest supporters of competitive energy markets would generally advocate for the view that markets alone will not support adequate transmission development. So I do think we need a regulator that's looking at the needs, but it shouldn't necessarily be in the CPCN doctrine, as Josh has identified. And as Josh mentioned in his initial remarks here, it really is worth emphasizing that infrastructure siting processes have become about a lot more than identifying just market demand. And the chief concerns now in this new regulatory context are the impacts of infrastructure on communities, landowners, and the environment. And so in that context, I would really agree with Josh that in cases where the existing doctrines have not already been revisited to more directly aim at those concerns, it makes sense to think about that and how they should be adjusted, because I think in a lot of cases, that is already the practical import of what states are doing. And I would say, though, that applying it to kind of the Arkansas example, so the particular factual circumstances of Clean Line aside, it does seem reasonable to me that states might not want an entirely unfettered market for transmission, given all of those potential impacts of infrastructure. You really wouldn't want like a fly-by-night operation with no financial security. I think Jessica mentioned this, developing your lines. It does make sense to have at least some sort of regulatory regime around who's able to construct. And also applying the insights to the paper to FERC siting of gas infrastructure, as Jessica mentioned, that process before FERC has generally resulted in pipelines getting CPCNs. I think in a way, Josh's insight makes that not surprising at all, because if the process is designed to look at market demand, but you've got competitive pipeline developers, then in every case you would kind of end up with demand being found. Although, you know, the context in which you might really need that type of regulation to ensure that demand is necessary might be where affiliates are developing and contracting with one another. And in that case, the test of looking at whether or not the parties have contracts with one another doesn't really do the job of assessing market demand. And then finally, maybe FERC has a few things to learn from the states of kind of aiming that process at the more relevant concerns of community impacts, landowner impacts, and environmental impacts. On self-commitment, as Jessica mentioned, the paper contains a recommendation for FERC to bar generators that receive rate recovery from state proceedings from participating in the wholesale markets. But I would say I would agree with her and Hampton that FERC couldn't really feasibly do that, nor should it, because I think this is primarily a problem, right, in vertically integrated portions of the market where generators are subject to rate regulation. So were FERC to adopt such a rule, perhaps we'd be left with no market to regulate because all of the generators would be gone. Now, we could try to get into a system of saying which state actions are legitimate and which are illegitimate. I think as the paper identifies, there are many cases where state rate recovery is perfectly legitimate if a state has an environmental policy they're seeking to shape their generation mix around. I would also note that in these regions of the country, states are responsible for resource adequacy, which can involve ensuring that certain generators are around to be there when called upon. But I would agree with Jessica and Hampton that that's a very slippery slope, as we've seen in the context of the fights around capacity markets and state regulation. But as Josh mentioned, there really is a zombie in the way that states are doing their rate regulatory processes. And I would agree with him that state regulators really are a good target for ensuring that the processes that they're using for rate recovery don't reward utilities that have dispatched their units in an uneconomic way. And they can be encouraged to police that and also to put in place regimes that will encourage more economic dispatch. Finally, on the filed rate doctrine, I would point out that there are many contexts where the commission doesn't rely on rate-making proceedings to ensure that rates are just and reasonable, but nonetheless, still a much broader regulatory architecture beyond simply presuming that freely negotiated contracts are permissible. As the paper identifies, FERC has a substantial body of regulation built around policing manipulative conduct. And so I think in that context, there's a question whether FERC's regulation can be implemented more effectively, as Josh argues, in tandem with other laws that regulate anti-competitive conduct, or if instead, if FERC is kind of afforded autonomy in that role as a sole regulator, that perhaps conflicts won't arise and it could be effective. So I think there's kind of a question there to be examined from the one the courts have looked at, but is still relevant. But my question for Josh on the filed rate doctrine is, if one accepts his argument that the filed rate doctrine is a zombie, then what would FERC's role be in attacking that? Courts could overturn it, but as an agency that is subject to judicial precedent, curious as to his thoughts on what the appropriate role for FERC is in that regard. So turn it back to you, Linda, and thank you.
Thank you, Miles, for those comments. I could see that Josh was writing down a lot, and we're going to hear from a minute. And Margaret, I apologize. I think I went out of order, but you know what? I'm the parent of a baseball player, and this is a really good deal because you're batting cleanup now for the commenters. So over to you.
Thanks, Linda. Not a problem at all. It helped to sort of alleviate my tension or my stress, so I do appreciate it. And it's good to be able to hear both Jessica's and Miles's comments on Professor Macy's article so that I can incorporate it and respond. So first of all, thank you for inviting me, for allowing me to participate. Good to see you all and good afternoon to everyone. My approach, or where I'm coming from, is a little bit different than everyone else here. That I am, as Hallie noted in the introduction, I am active within the field. I'm an attorney, a practicing attorney, and based on my client base, I do see a lot of these issues. And so coming to this from perhaps not to disparage, but coming to it from a little bit more of a practical approach, if you will. So when I hear terms like generation and transmission, my mind immediately goes to sort of what those terms mean within the context of what I'm doing and what I'm practicing on a day-to-day basis. So I'm going to start, first of all, just by, I think, acknowledging what Professor Macy has laid out here. Certainly the history that's led to where we are is good to understand and know. But I would agree with Miles that a sort of slash and burn approach. I was thinking something more sort of medical, but I think the slash and burn works well with respect to the zombie analogy. And I was trying to think of like, what could I use to say, okay, these aren't quite dead. I think they're alive and kicking. And I think that they are still particularly relevant today, again, as I look at these issues from a practitioner's point of view. So I will say that given my focus on federal energy regulation, I am going to set aside discussions with respect to CPCN. I think Jessica discussed that as well as Miles, but it's not something that comes before me at quite a bit. My focus tends to be practicing before FERC, and again, those issues are more state issues, so I'm really not going to address that here. But when I look at your discussion of Professor Macy's discussion of the filed rate doctrine, that is one that I think reacted to somewhat viscerally when I read your article, because I did think that it is in fact alive and kicking. Understand your perspective as to the filed rate doctrine and how it may be applied within the judicial system. But before FERC, it's a tool that certainly I utilize, and I know other practitioners utilize, both for vertically integrated utilities as well as the customers of those vertically integrated utilities. So we look at customers, the generators that you are discussing, the renewable energy generators that you're discussing, they tend to be customers of these vertically integrated utilities as interconnection customers, and they're also transmission customers. And when you consider that the idea of rates, it includes not just what are we going to charge, but also the terms and conditions of taking service from a utility, that also is considered a rate when you look at a tariff. And so the ability to have a tool like the filed rate doctrine to assist a customer with ensuring that what rights or obligations are to which they're entitled under a particular tariff, that they're able to have the resource and ability to challenge a utility's deviation from what is on file at FERC, what has been accepted by FERC, by using the filed rate doctrine, among other legal doctrines, to assert their rights to particular types of services, and to assert their rights to services as those services are delineated and explained in a tariff is an important thing, and it's a useful thing within the industry. And so I do think that perhaps approaching what you propose from a more surgical standpoint, so to the extent that you are proposing that there be some limitation or reversal of the filed rate doctrine, if you're discussing this at the judicial level, and this perhaps goes to the last point that Miles made, sort of how do you see that, or what do you do with that before FERC? Whether there is some other mechanism or tool or approach that one can use to allow a litigant, let's say, within the judiciary system to achieve its goals, but not completely eradicate the ability or the availability of the filed rate doctrine within the regulatory scheme or the administrative law scheme. The other thing to think about too is that when we talk about a utility, you describe utilities, and it seems to me, I'm sorry, Professor Macy, that the concept of utility in your article appears to be almost exclusively the vertically integrated utility, right? The utility, almost, but not quite, but the vertically integrated utility that has transmission, that has generation, that might be competing against generators that also are customers on the utility system. But again, to keep in mind that the utility today can include merchant transmission owners. The utility can include cooperatives or municipal or state-owned transmission organizations that choose to participate in a regional transmission organization, and so allow themselves to be subject to FERC's regulation with respect to their transmission use of their transmission facilities, or it can mean the RTO itself. So again, when we look at the file rate doctrine and the ability of a customer to be able to utilize the file rate doctrine as one of several tools to allow it to ensure that the rates that it anticipates, it expects based on what's on file at FERC, being able to use that tool to challenge the implementation of a particular rate, terms, conditions, et cetera, by, let's say, an RTO. When you look at the voluminous open access transmission tariffs or market tariffs that one might see at an RTO, and the business practice manuals that are attendant to these rules, and being able to navigate these documents in order to ensure that the service that you have sought, or that your expectation with respect to the service is what you're getting, is, I think something that, again, this is a useful and helpful tool to allow them to be able to do that. And then as to rate recovery, I would say that I guess also, again, stepping back as to and looking as to who is recovering. So your discussion, I think when I heard Jessica speak, and you, Jessica, I think you framed it in terms of retail rate recovery. I think that's perhaps where my mind was going, because I look at this, and again, based on my practice and looking at this from a FERC rate recovery perspective, I took issue with some of your arguments, because it seemed to me that while there are mechanisms that allow vertically integrated utilities to recover fuel costs, for example, at the retail level, and that may give them some edge in the competitive markets, that I don't see this as such a prolific problem to require the I think the sort of overarching or I don't use the word aggressive, but certainly the approach that you are proposing with respect to rate regulation and not allowing a utility to recover its rates. That process from a FERC perspective, the cost rate regulation is still particularly alive and well at FERC. From a transmission rate perspective, transmission rates are generally cost-based. And again, when you look at the entities that own transmission are looking to recover rates that they have proposed, and then being able to use the system that I understood, at least, you were describing within your paper, Professor Macy. I think it's something that is utilized not just by vertically integrated utilities, but also by non-traditional utilities, if you will, that are within the FERC rate making space. And so I still find that there is room for that concept within the FERC rate making space. But to the extent you're discussing this within retail rate regulation, there may be some room and space for that. But again, just wasn't quite sure. Impacts on the market with respect to the ability of a utility to recover. I think one of the things that struck me was not denying that these types of activities may take place, but given the current market scheme within RTOs and ISOs with independent market monitors, FERC itself has a market surveillance team, FERC enforcement staff, and so the the intent of a party or a party's intent to manipulate, let's say, the market by economic withholding, that is a blatant violation of FERC's rules and subject to FERC enforcement action for doing so. So perhaps what you discuss is not manipulation within that framework or context, but it's certainly how I read it based on how I practice. And so that was something that in reading that and looking at that, to me, again, I thought that there are systems within the competitive market as it stands today that address these issues, and that your proposal for taking away or removing the ability of utilities to recover these by relying on that rationale wasn't something that I thought should be encouraged, if you will. So I enjoyed reading your article because I think it, for myself, again, as a practitioner, I don't really read and look to academic writings as a guide or a check on what I do, but it certainly did challenge me in some respects. So I do look forward to hearing your comments in response to what I've said. Thank you.
Thank you, Margaret, and thank you, because that's exactly what we're trying to do, is bring ideas from academia to real people who don't have time to read heavily footnoted law reviews. So, Josh, I'm sure you are ready to respond to all that you've heard, and it's been a lot. So over to you for some reactions.
No, that was really helpful, and I enjoyed all of your comments. I appreciate the comment about MOPRs. I've written about MOPRs. I think there are ways of distinguishing between actions such as that send a price signal that can be incorporated into wholesale markets, and actions such as fuel pass-through agreements that override market signals, but that's a separate argument. I also briefly want to touch upon Miles's comment about FERC's gas siting process, where you can sort of understand the history of gas pipelines as sort of shifting in the direction that I propose. And one thing Miles pointed out, which I had never thought of, but is really, I think, quite brilliant, is that in some ways, in recognizing that whenever there is a contract for gas development, we basically rotely approve it. I think elides the difference that I cared about in the transmission context between a finding of demand and these other protections. And I think I hadn't thought of this until you made that comment, but FERC might think about that, the sort of licensing idea. But mostly I want to talk about the filed rate doctrine and go into respond to what Margaret said, because I found your comments very interesting. I strongly disagree with them. And I want to explain why. So you, as I understand it, and I've heard this argument before and I find it very interesting, are arguing that the filed rate doctrine provides an opportunity for regulated entities, whether they're vertically integrated utilities, merchant transmission lines, generators, or customers, to challenge misconduct such that they can ensure that the tariff is filed, and not just the price the price, but also the service obligations. Now, I think that I keep hearing this argument, and it's entirely possible I'm just sort of missing something, but it occurs to me that, of course, that's what a contract does. And what the filed rate doctrine does is it creates uncertainty. So if you look at the PG&E bankruptcy, and this is where I think I butted heads in some respect with quite a few environmentalists, where in PG&E is bankruptcy, a lot of people I generally agree with were very concerned that California solar contracts would be rejected in bankruptcy. And they tried to invoke the filed rate doctrine in order to argue that FERC could mandate, could basically review a bankruptcy court's decision under the filed rate doctrine, such that solar contracts would not be rejected. I don't understand that to be protecting contracts or even protecting renewable developments. I understand that to be creating uncertainty about contract rights, and also to making, if these large, ComEd was one of the people arguing for FERC review. And what they basically were arguing was that they failed to buy credit default swaps that would have hedged them against counterparty credit risk. And they wanted a second bite at the apple. And so in my opinion, all of these benefits that customers should, if they feel that the utility, and I certainly and obviously agree that under the Federal Power Act, utility does not simply refer to vertically integrated utilities. If they are dissatisfied with a rate, they have a contract right to challenge it. And what the filed rate doctrine does is it gives FERC discretion to undermine contract rights retroactively. And I think getting rid of the filed rate doctrine, because what FERC can do, according to case law, is it can even, it has to respect Mobile Sierra doctrine, but it can still revise rights if it finds that they're unjust and unreasonable. And that is a exceptional sort of energy exceptionalism that I think is worth pausing, because I don't think what that does is it creates protections for customers. I think it means that some regulatory body can decide to revise the terms of a contract ex post, such that if it determines, and you may think, oh, I really thought that those California solar contracts were necessary to encourage solar development in California, but it also means that you might find in the future PG&E demands refuses to provide as friendly terms to solar developers out of concern that it will be unable to reject them in bankruptcy. And so interfering with those market processes is something at least I'm pretty concerned about. And I guess ultimately, and I really enjoyed your comments, but I don't see, I'd love to, and maybe talk to you offline about in what respects the filed rate doctrine protects parties to a greater extent than having the regulatory bodies that have experience enforcing antitrust, because there's a wealth of literature showing that FERC systematically under-enforces market manipulation. And that someone like the Federal Trade Commission should be pushed out, and we should allow a regulator that doesn't specialize in this matter, such that that regulator, which has to balance all sorts of things, is also the antitrust regulator in energy markets. But the comments were really interesting, and I do want to have time for questions, so I'll cut myself off there.
Thanks, Josh. I do want to just give the other commenters a chance to respond if they would like to now, or they can wait.
Josh, we should talk offline, because I do hear what you're saying, and I think it may warrant sort of a stepping back and looking at the different contexts in which the filed rate doctrine is employed. And so your discussion of the PG&E bankruptcy and what was going on there, and this is something too that, as I read your article, I wasn't quite sure that I was following, is that Mobile Sierra, the standard for FERC review of a contract between parties under Mobile Sierra is that they look to see whether the proposed, the change that's being requested is just and reasonable. And they also determine it based on what's in the contract itself. There is a higher standard or public interest standard that's applied to the extent that there isn't, that one party is looking to unilaterally revise the contract, and there isn't anything in the contract that says, okay, you can go ahead and do this. And so I don't really see that. To me, that's a separate doctrine, and that's not the filed rate doctrine that applies there. And so that's one of the reasons, that was one of the issues that I had. So, I do think that it's worth, I don't know if you have another symposium, Linda, but to be able to sort of delve into that a little bit more, understanding and appreciating that within the context of, again, I just haven't read a law review article since I was an associate editor for the law review, but there are a lot of pages, and even with as many pages, there's still so many issues or so many nuances to the issues that it's really hard to cover it all within the context or the four corners of the article. So I do think that there are some sort of tangential issues that you bring up that I think are related to other legal concepts, but I do still fundamentally believe, which we clearly disagree, but I do still believe that the file rate doctrine does serve its purpose in particular contexts for customers and market participants within the federal energy scheme and federal energy regulatory scheme. So I'll leave it at that.
Thanks, Margaret. I guess we will now go to our first question from Hallie.
Yeah, my question, I think some of the commenters have touched on a little bit, but Professor Macy, it's for you. In your article, you suggest that it's relatively uncontroversial that FERC has the power to abandon the particular zombie energy law of rate regulation for vertically integrated utilities. And I was just wondering if that is the case, in your view, why has FERC not done that yet? What were the impediments, and maybe why do you think now that change could occur?
Oh, I think states, well, there's a lot there. I have a sort of minority view that FERC can mandate RTO membership, but that's a separate point. So I'm not going to go into that just now. But the Federal Power Act has a fairly complicated jurisdictional scheme that I've written about at length in a different law review article. I don't think FERC can directly. It is uncontroversial that states have authority over generation facilities. And so FERC cannot directly tell states to stop doing some things with respect to generation. I do think, and regardless of your views on MOPR, FERC's authority over wholesale market processes that it supervises through RTOs is large and significant. And I don't want to sort of say FERC should just MOPRize generators that are benefiting from cost recovery. But I do think FERC can be creative about making states that are nominally participating in competitive markets, and in particular, I'm thinking of MISO here, but that are really protective of certain favored generation units. It can do things to make those generators hurt. And I think FERC might consider, now I recognize no one until today has ever accused an article I've written of being practical, but I think FERC's jurisdiction over wholesale market processes could allow it to protect those markets if it feels that there's distortions arising because of pass-through agreements. But it's a great question, and one should be a little cautious because of states' authority over generation units.
Does anyone want to else jump in on answering that question? Miles, perhaps?
Sure. Yeah. I mean, I think as I mentioned earlier, I do think that could be a very fraught area for FERC. And so Josh is right that FERC has authority to regulate its own market rules. But I think with regard to discriminating against the legitimacy of different state actions versus others, that's very dicey, and it does, even kind of raising that potential for regulation, I think has a bit of a chilling and uncertain effect on state regulators. And I would also just flag that in this context, there's actually a lot of room for cooperation. So the market monitors in a couple of the regions have done reports looking at this self-commitment activity. States could ask FERC to tell market monitors and the RTOs to kind of flag behaviors. There's an opportunity under the Federal Power Act for joint boards to look at issues that implicate this kind of overlapping jurisdiction, and also ways in which, in theory at least, FERC could provide technical support to states as they engage in their own regulatory activities, because it's actually pretty complex to distinguish, is this fuel adjustment clause really necessary or how should it be arranged, et cetera? Is this unit losing money? And so yeah, I would just flag that there, it's really like sort of constraint. The commission is tackling a very ambitious agenda right now, and so kind of figuring out what is the right role is challenging.
Thanks, Miles. Hampton or Jessica, do you want to add anything before we go to the next question? And you may have noticed that another third-year law student has joined us, Molly Harwood, who is going to be closing out the conference in a few minutes. Jessica or Hampton, do you want to jump in or go to the next question?
No, please go to the next question.
Okay, and I think you're going to use your sponsor of the program prerogative here.
So I want to just sort of take it maybe to a 30,000 foot level a little bit, Joshua, and maybe that's because I'm not an energy law expert. I like to.
I'm going to keep talking about the filed rate doctrine. So
yeah. Now I just but one thing I find fascinating is how much the discussion, whether you're on the FERC staff or writing about energy pieces or advocating for them, seems to basically take a certain amount of demand as a given. And we spend all this time talking about the generation, the environmental characteristics of the generation, the transmission, the siting of transmission, and the regulatory framework for all that. I looked at I think it was the third slide that Hampton showed, the power sector in the states. And this is just one example about how our whole mental model affects how we think about this. I think the slide that he showed was exactly on target. It's the one everyone shows, and it shows the residential line as being somewhere under double digits of total U.S. contribution, I think, to greenhouse gas emissions. And that's only true if you assume that all of the electricity used in households gets attributed to the electricity sector, right? And all of the emissions associated with transportation get attributed to household transportation, get attributed to the transportation sector. And what that tends to do is it tends to take our attention away from the fact that if we put those two together, then households make up 30 to 40% of US greenhouse gas emissions. And now all of a sudden they begin to seem like a source that we might worry about, which gets me a long way to the next piece of it, which is, in the last 10 years, for the first time since the Second World War, the household per capita electricity consumption has leveled off and has begun to decline. And there's really good work by Lucas Davis, an economist at Berkeley, that shows that correlates almost exactly with the uptake of LED light bulbs in homes, which was largely because after some standards by government, Walmart and Target insisted on making good, attractive light bulbs as their house brand. A long way of saying, Joshua, is there an aspect of zombie laws which is related to the demand for electricity, particularly household demand, or is that something you've looked at? Or is this just a matter of us? And again, one last thing, I serve on the board of an electric utility, and we want to sell more of our product, right? We don't really have an incentive to sell less, but it's not in the social interest if we're trying to decarbonize society and reduce the demand on fossil fuel sources for us to keep doing that. So I'm curious about how this all links together and whether that's another paper down the road, perhaps, or buried into this one somewhere.
Yeah, and this actually ties into the coal ash discussion. I'm writing a paper on coal ash and utilities' responses to liability rules. But the seminal paper about this is by Harvey Averick and Leland Johnson. And what it shows is it documents a phenomenon called gold plating, where utilities, unlike any as long as you're rate regulated, and by utilities I mean rate regulated utilities under the INSO model, have an incentive to increase costs, that a utility, as long as it can rate recover, it doesn't care if it has a $9 billion slab of concrete that's a failed nuclear reactor in the Carolinas or is producing electricity, that if it can go to its regulator and say, we have $100 in costs, it makes a return of $8. If it says we have $1,000 in costs, it makes a return of $80. This is economically crazy. It's also, from the perspective of decarbonization, very, very difficult, because what utilities want is they want costs that a regulator, and caveat, I'm meaning the INSO rate regulated model of utilities, they want costs that a regulatory body says, oh, you can recover those costs. And given the importance of efficiency, as you rightly point out, that means that the companies that need to drive efficiency innovations really hate efficiency, because it cuts into their rate base. And it's a really, really deep problem. And one of my concerns with markets that are not restructured is that even if you have a completely benign, sort of wise Platonic philosopher king, it's going to be really hard to get a regulated entity that's going to do everything it can to keep increasing its costs. Now, I'm sure people are going to say you can have innovative rates, you can structure rates so that they're tiered, and you can do all of those things. But at the end of the day, compared to competitive markets, where if you don't cut costs, some competitor will eat your lunch, it's much, much more difficult.
Wondering,
yeah, please.
I wanted to just say, so I generally, I appreciate what you're saying, Josh. I do work with a utility that its sort of overarching approach is a social responsibility, if you will, right? And so it has initiated a program that puts battery storage within the homes of their ratepayers in order to, well, one, it reduces demand, and then they have a resource within, the battery systems that can be used to provide ancillary services to help to support the grid. I mean, it's not a large utility, but it's something. And so when I hear the question, I think about, we step back and we think about sort of where we are as a society and what we choose to prioritize as a society as our goal. So we all say that most people say that they want clean energy, but then when the sort of rubber hits the road in terms of what that means, then there are pressures that are put, whether it's on the utility or on businesses, as to how does that translate into pass-through costs for the customers, in addition to what it may mean for their lives day to day in terms of the air they breathe. But I do think that's something that when I look at this and I look at the utility that I work with and I look at sort of, okay, well, within our social construct and what we as a society, and using that term very largely, what we determine our priorities, it's something that I think that, that informs that conversation, that discussion.
Yeah, two really quick thoughts on that. One is I found it fascinating, again, being a member of a board, how much people will push for low rates. But what we really, if we care about consumers, what we really care about is the energy burden itself. It's the rate times the quantity purchased. But often these rules are set up to only focus on the rates and not the quantity. And so there's a whole component here that's missing. It's fascinating. And if you look at the 10K for TVA, for example, it puts efficiency and conservation as a material threat to its operations. And I think that's sort of tells you what you need to know on some level.
Well, we are out of time, and Molly Harwood is going to close us out. She's a third-year student at Vanderbilt, and I just want to thank everyone. This was a great panel. It was a great day.
Yes, thank you so much. Really excellent panel.
And Molly, over to you.
Great. So I am the executive editor of LPAR, and I just want to take a second to say congratulations to the authors who were selected for the 2021 publication. We sort through hundreds of articles every year, and your articles were the most persuasive, the most feasible, the most impactful and creative proposals that we read. So congratulations. And thank you to all the panelists who spoke today. The purpose of LPAR is that we don't want academia to exist in a vacuum, and you all made that possible. So we are very grateful for your voices and your time. Thank you to the members of LPAR who coordinated this event, especially Connor Farley, who is our symposium editor, and a special thank you to Heather, who feels like a part of LPAR and knows all about the technology, so we are very grateful for you. Most importantly, I want to say thank you to Professors Breggin and Vandenberg, because without you, obviously, this would not be possible. We benefited so much from your guidance, your support, your passion, and your knowledge, and we've learned so much from both of you throughout this process. Even in a pandemic, this went off without a hitch, which is very impressive and cannot be said for everything. And last, I would like to thank all of you who attended. It is a very long day to sit on your computer and learn, but it has been an incredible day and I've learned a ton. So thank you to all of you for sticking around. The select few who stayed for the whole day, we are very grateful for. Everything you heard today is going to be available on the ELI website, including recordings. I think it'll be a few weeks before they are up there, but they will be there. And for the first time, which is very exciting, the articles and the comments will be available in August on the ELI website. And I hope this isn't naive to say, but we hope to see you all in person next year in DC.
Thank you, everyone. Have a great rest of your day.